Yes.
Waiting to come at 12 noon, my lord. Yesterday, my lord was pleased to
But,
observe. Yes, something has happened in the
Secretary informed me that Honorable Chief Justice will take up the matter himself. So you may move to PIL bench.
my lord.
Okay.
My lord. Today, so
I have been informed that Chief Justice will take up the matter. The returnable 20th. That means today.
yes, but today's matter is not.
Not there, but I have received phone just 5 minutes ago. That's why I got late for 2 minutes. Okay.
Deep level.
Original side commercial division, item number 1.
Appear for the decree holder, my lord.
Lord, I appear for the decree holder. There was a direction passed by your lordship issuing a warrant of arrest against the judgment debtor. My lord, the warrant had to be executed by the department. We had put in the requisites. My lord, lordship will kindly call for the report from the deputy sheriff as to whether the warrant has been executed.
Okay. Yes, you are for the decree holder.
Yes.
So pass it over. Pass it over. Report to chain out.
Original side matter to be mentioned, item number 1.
My lord, I am appearing on behalf of the decree holder bank, Bank of Baroda.
Yes.
My lord, in 2019, the learned Lok Adal passed an award. For the execution of that award, I have filed this suit before my lordship, and Honorable Justice Devanshu Bhasak was pleased to pass the order that within 2 years from the date of the execution petition and award maintaining satisfied and my lordship, after that, the judgment debtor, he applied, came to to me to settle the matter through the compromise. And the compromise amount has been paid by the judgment debtor. For that, my lordship, now we want to withdraw this suit because already we have satisfied of the amount which has been paid by them through the compromise settlement. That's why.
So interpayment has been
the
made.
matter for non-prosecution, my lordship.
So you do not want to proceed with this case?
My lordship, as we have got the money to the compromise settlement, my lordship.
Please issue notice upon the award debtor and then come back. Okay. Please issue notice upon the judgment debtor.
My lord.
Okay.
My
then
lord.
come back.
My lord.
The learned counsel for the award holder submits that by virtue of a
Appearance.
compromise taken place between the parties, comma, the awarded sum has been received by the award holder. Stop. The learned counsel, what is your name?
Apurba Kumar Bandyopadhyay, my lordship.
Mr. Banerjee Bandyopadhyay has submitted that his client, namely Bank of Baroda, wants to withdraw.
My lordship.
Wants to withdraw the instant execution proceeding. Stop. Para. I want to hear the award debtor in this regard. Issue notice upon the award debtor accordingly. Stop. List the matter when? When I shall fix it?
Next week, my lordship.
List the matter after 7 days.
My lordship. Much
Date bole din. 27th.
27
my lord.
এইটা রেখে দিন।
কোন হেডিং আসবে? এই হেডিং আসবে না তো। হ্যাঁ, এক্সিকিউশন কেসে
that বলেছে 29th এ দেবে।
আইটেম নাম্বার 2
I appear on behalf of the decree holder. I appear for the judge. I appear for the son of the judgment debtor. I appear for the wife of the deceased defendant. I have applied 29th, my lord. Perhaps I'll get the original. That's Lordship said, my lord.
Your wife and who is for the daughter? So everybody has come up.
But only one
See the power of the order.
But only one submission before your lordship. Lord, the erstwhile
I was making my submission. My lord contention. Lordship, we are today only on mutation under 183 of the Kolkata Municipal Corporation
Now,
Act.
how is the
That I have said, my lord, so far I am concerned, it's recorded in the order, is Lordship's view, my lord, I should apply for and give a original death certificate. That I have done so. It will be given on 29th of February.
and I have
2024.
I have also asked a affidavit from you.
Yes, as your lordship
Taking you have to state that who are the present legal heirs of Nawab Yusuf. This is
Yeah, the affidavit is not there coming, my lord. I have intimated them.
Lord, I'll tell your lordship.
If once, my lord, will file an
who are
affidavit.
the legal heirs of
I am appearing on
you let that be
behalf of the doctor. Lord, the erstwhile learned advocate for the doctor has passed away last week. Lord,
Oh.
I'm still giving instructions from the
okay.
instructing advocate. Lord, I'm still to get the papers today. Lord, once it comes, Lord, I will file an affidavit also in the matter.
Who was the advocate?
Lord, Somi Guru Apurba, no, earlier erstwhile in Mr. Shakil Ahmed, he passed away. And right now, Lord, my instructing advocate is one Somi Guru Apurba.
Oh,
She has instructed me to
so have you submitted Bhukalatnama?
Lord, I am undertaking to submit it of today or tomorrow. It's kindly submitted to
You have submitted.
No, my lord. We need to leave, my lord, to file the wakalatnama because we are not a party in the original execution, my lord. So a leave has to be given by
Same,
my.
my lord, here I was addressing, I did not, my lord, want to press this technicalities and scuttle the hearing. Shananda Ganguly, my lord, is my advocate on record, my lord, lordship, because since execution I had said, my lord, that it doesn't, my lord, await or a party should be awaited. It should be proceeded against the years under the, my lord, order 21. So, my lord, lordship has to give, normally what court is not asked for, it's a misdeed. I could a leave has to be given, my lord. This is Shananda Ganguly. Will file, Miss Sananda. My lord, my advocate on record, my lord, since I am also not a judgment debtor, but a son of the judgment debtor, who is, my lord,
We are not a party.
we are not party, but not necessary to be made party.
So anything to say because your senior was there?
Yes, yes. I was being led by Mr. Rohitland Mitra.
Rare,
Answer short pass over, Lordship. He is on his
Okay. Just give 5 minutes pass over. 5-10 minutes pass over. Okay.
Lordship will kindly excuse me if I am not there, I'll be.
Okay. Your junior will be here.
Only, my lord, the endorsement, lordship, I am appearing, my lord, also. Endorsement on the backside of the wakalatnama. Okay. I am appearing also, my lord, I am arguing.
So you are the senior counsel. That's why.
No, I am not a senior counsel still here. I am led by a senior counsel.
No, senior. There is a difference between senior advocate and senior counsel. So you are a senior counsel.
Well, I will at lordship simply personally, I normally do not ask for time.
item number 3
My lord, here I appear for the decree holder.
Not I appear for.
For the judgment debtor.
Lord, I have received instructions that the judgment debtor will be handing over a draft of rupees 3 lakhs. But if they hand over the draft, my lord, then the execution can be disposed of.
Yes.
Yeah, your lordship.
Take the microphone.
The judgment debtor has died, your lordship. Today I am producing his death certificate, and as per the instruction, there is a settlement between the parties, and within the course of that they will pay the amount. If your lordship kind enough to fix the matter tomorrow,
At 2 p.m. No problem.
as your
You
lordship.
please come at 2
Yes,
p.m.
lordship.
Hey, Raza,
Very good.
রাখতে হবে নাকি? At 2 p.m.
Grateful, my lord.
2 PM তা 2 PM আবার কালকে হয়। Item number 4
My lord, item number 4.
I am for the decree holder. It arises from a suit for partition, which was decreed on the basis of terms of settlement. On the last occasion, on 21st of December 2023, your lordship had directed the receiver to be communicated so that the receiver could disburse the money that he was holding on to. In terms of that order, we had written the email as well as the letter to the receiver. Yet till now, we haven't heard from the receiver officially.
Who is the receiver?
Receiver is Mr. Sinha. Now, yesterday I was approached by him informally in court, and he said that without getting the details of the accounts, he can't transfer the money. So I asked him to write it out formally to my advocate on record, so that things can be done in a formal way. Because we had communicated on, after this order was passed on 21st of December, and immediately afterwards we had communicated on 22nd of December, followed by 16th of January as well, because we didn't hear from him. So both the occasions, he said that yes, I will disburse. But thereafter, informally, yesterday only I was informed by him that without getting the details, he can't transfer the money into the account. So be that as it may.
Call the learned receiver before me.
Yes, then that would be better, I believe.
Hey, do
And
not-
also, my lord, another instruction.
At 2 p.m. Please come at 2 p.m.
My lord,
Ask the
I shall do that. Also, my lord, I should bring it to your lordship's notice that day before yesterday, we have come to learn that the defendant in the suit, who is now the judgment debtor, she has passed away, my lord. So we have to carry out the amendment also now, given the fact that it can't be executed against the dead person. So her heirs have to be substituted. Have been also provided to us. So we shall be taking necessary steps with regard to that. But if your lordship so directs,
The learned counsel for the judgment debtor has submitted that the who died?
this is
Judgment debtor now?
Hajra Parveen, judgment
Yes,
debtor.
yes,
yes. One
Hajra,
judgment debtor.
yes, there is only one.
The judgment debtor,
Sister,
Mrs. Hajra Parveen.
Parveen,
Parveen has died when?
31st January.
31st of January 2024, and it was communicated to us on 15th of February.
31st January 2024. And the learned counsel has also handed over the particulars of the legal heirs of the deceased judgment debtor. Stop. Handed over to the learned counsel of the decree holder. Particulars of the legal heirs of the deceased judgment debtor have been handed over to the learned counsel of the decree holder. Stop. Where the learned counsel for the decree holder has sought for an accommodation for amending or amending for substituting the legal heirs of the deceased judgment debtor. Stop. When?
My lord, within 2 weeks, we shall be carrying it out.
Please the matter. After 2 weeks. 6 months.
My lord, we shall
The
actually have
learned
to.
receiver is also directed to appear on the date fixed before this court.
My lord, in all fairness, I should point it out before lordship that I will have to come up with an amendment application in terms of this order. And that's the standard practice. I have to come up with the amendment application, and accordingly, your lordship will pass the order
Okay.
allowing that. Thereafter, department will be directed to carry out the amendment.
So after 2 weeks, it will.
Yes, within 2 weeks, I shall take all the necessary steps and I shall come back.
Okay.
Your lordship can make it returnable 2 weeks hence.
List the matter on 5th March. The learned receiver is directed to appear. The learned counsel is to communicate this order to the learned receiver.
I shall do that. Grateful, your lordship.
The matter will appear on
5th of
5th.
March. At that आगे मैं application बोल रहा हूँ. Grateful, your lordship.
Item number 5.
Your Lordship,
This matter is
কি বলছে?
this matter is fixed for filing of the written notes.
Your Lordship, I'm praying for a short passover, Your Lordship.
Okay, pass over.
Lordship, it's only for filing written notes. May my learned friend also file their written notes in the course of the day.
Satyaprakash ji,
It can be filed in course of the day.
Your Lordship, we will file in the course of the day then. Lordship.
The learned counsel for the judgment letter completed his written notes of argument. The learned counsel for the decree holder said that he will file the written notes of argument in course of the day.
Ma'am, can I file this, my lord, notes of argument on due course of day, my lord? It is ready.
Ready? File.
My lord, it is getting ready, my lord.
Okay.
Should maybe have a copy.
Yes.
I have
Exchange.
not, You
Exchange.
have not given me the copy of your notes of argument. Provide me.
Then oral argument will commence. After getting the copy.
I will give you.
Okay. In course of the day, you
Yes,
please
my lord. Yes.
exchange copies if you so desire. Next. Judgment is reserved হবে এটা। হ্যাঁ। Argument is concluded for all practical purposes. Stop.
CPC.
তাহলে আবার একটু তখন অর্ডারটা হবে আর দেখে নিন আজ আমার কতগুলো আমরা সিএবি হোক তুমি লিস্টটা পাঠাও সিএবি আর অর্ডারের জন্য কটা লিস্ট পাঠিয়ে রেকর্ড গুলো পাঠাও না তো আটকে যাবে তাহলে আমাকে লিস্টটা তো দিতে হবে আমাদের অর্ডারটা কবে দেবো না দেবো ঠিক আছে
সিএবি হয়ে গেল এটা।
জাজমেন্ট ইজ রিজার্ভ
Item number 6.
My lord, I beg to appear, my lord, for the judgment data number 2. Second, my lord, may I have my lord leave, my lord, to appear through VC, my lord.
who is for the decree holder
My lord, the decree, my lord, decree holder is Bama Lorry and Company Limited. What has happened, my lord, in this matter? We have filed, my lord, an application under section 47 of the Civil Procedure Code. That was marked as GA number 2 of 2022. Now, my lord, on 13th of February 2024, my lord, a date was fixed before your lordship, and a letter was circulated beforehand by my learned advocate on record that a short accommodation, a short extension of time would be prayed for before your lordship, my lord, for filing rejoinder, filing affidavit in reply. But my lord, it so happened as it transpires now, my lord has been pleased to pass a detailed order, my lord, on 13th of February 2024 at the instance of the decree holder as well as, my lord, the judgment data number 1. Now, my lord, this is a case. So will it be my lord's pleasure, my lord, to have my lord's order dated 13th of February 2024?
you are appearing on behalf of whom
I am appearing for my lord one Arun Subbarao Shetty, who is the defendant number 2 and decree holder number 2.
decree holder
I'm appearing with
I mean judgment data number 2. I'm so sorry. Judgment data number 2. Now
I'm appearing for the decree holder minute. I'm having some difficulty with the camera minute. My
Yes.
junior is there in court.
yes
Yes,
Now,
but
my
there
lord,
is some issue with my camera.
now, my lord, what has happened is, my lord, this is my may I place your lordship, my lord? Place before lordship. Hello.
Yes.
My lord, I'm for the decree holder. My senior Sonal Shah is appearing on virtually.
yes
Now, my lord, may I place my lord's order?
I am
Judgment
judgment
data
data
number
number 2.
one.
I am being led by Mr. Chakraborty, your lordship.
My lord, I am leading her and my learned advocate on record.
judgment data number 2
Yes, your lordship.
and who is judgment data number 1
Judgment data number 1 is Arun, my lord, Ravi Shankar Ramachandran. Mr. Shakko Sen appeared on their behalf the previous day.
okay
And he
Let
regularly
me
appears
recall.
for-
Miller will recall this is that matter where judgment.
My lord, may I
number
place?
one
My lord, may I
has
place? My lord, my lord, may I place? My lord, they
Discuss-
have. May I?
and your juniors are understanding what is the difficulties going on here just wait for 2 minutes
Yes. May I place this order, my lord? The learned counsel for the decree holder and judgment data number 1 have submitted.
ask your senior to stop for timing I am reading the order passed by me
Yes, yes.
Yes, the interim order in respect of other judgment debtor is extended till further order.
Further order, my lord, on the strength of this order, my lord, passed by your lordship, my lord, the bank account of the judgment debtor number 1 has been defrozen, and my lord, the order of status quo, my lord, has been vacated. Now, my lord, we are seriously aggrieved by this. Why, my lord, may I show your lordship? Today, my lord, I wanted to, subject to my lord's pleasure, I wanted to argue, my lord, on my section 47 application, but it has come to my knowledge last evening, late last evening. My lord, may kindly take up, my lord, my application under section 47, the paper book once, 47 of the Code of Civil Procedure, page 94.
That before my learned senior friend proceeds with his matter, Millet, they were supposed to file a reply. We have till date not received a reply, copy of their reply.
Milord,
Is it not my learned friend's intention that he doesn't want to file a reply? If that be so, he can proceed with the matter, Millet.
My lord, whom shall I listen to? Who will decide, my lord, your lordship or my learned friend? Who is in a place to decide, my lord, as to what should I do and what shall I do? Particularly in this changed circumstances, my lord, may kindly have my section 47 application once.
Have sought for accommodation for filing affidavit in reply. Your junior has taken has taken the adjournment on last occasion. What is that?
No, my lord, my junior could not take, my lord, my junior. What happened, my lord, in spite of that letter, my lord, these two parties, the judgment debtor number 1 and my lord, the decree holder, because this is our consistent case that they are in connivance with each other. And my lord, by reason of such connivance, the decree was passed.
Whether you are ready to file the affidavit?
We will not file rejoinder affidavit, my lord. With regard to my section 47 application, we will not. It is a question of.
What are you? Will you argue or will you file any application or anything?
My lord, I will just, my lord, may kindly hear me for 5 minutes. My lord, I was prepared to argue section 47, but because of this, my lord, may I first draw my lord's kind attention, my lord, to how this order has been procured by them, my lord. This is absolutely, my lord, they misled this honorable court, my lord, and they passed an order by which, my lord, the entire section 47 application is, my lord, intended to be made infructuous. Now,
you were present at the time of hearing.
No, I was not, my lord. Unfortunately, my learned junior was present.
Junior was present.
Yes,
and
yes.
You are using the term that the order has been procured.
I will, because, my lord, no, procured in a sense, my lord, that this court has been misled. My lord, there is absolutely no application made before your lordship. There is nothing on records. So, my lord, if somebody.
You please file an appropriate application.
Application, that's right, my lord, absolutely. That is exactly what I want to say, my lord.
You are from Delhi or something like that?
Yes, my lord.
The Supreme Court, I think.
My lord, I no longer live in Kolkata, my lord, I live in Delhi, my lord. Now,
in view of such submission, the order dated 17th August 2022 in respect of the above bank account is modified by allowing the judgment debtor number 1 to operate the said bank account until further order.
Now, my lord, I would file an application for recalling of this order, but may I just tell yes, I will file, but may I just tell your lordship now, my lord?
You did not properly instruct your junior at that on that day, I think.
My lord, I cannot instruct my junior. My advocate on record has to instruct me and the junior. So, my lord, I have nothing to say on with regard to that. Now, my lord, even today I find that my learned the junior counsel does not have any brief in front of her. It is now, what can we say, my lord? Because we have never been trained like this.
It's between you and your junior.
My lord, the entire bar has become like this, my lord. I mean, those days are gone. I mean, when we joined the bar. Now, my lord, may kindly come to page 94 of my section 47.
Appropriate application?
Application, yes, I will do, but I will just simply show my lord, my lord. Yes, certain. My lord, I can't hear your lordship.
94.
Page number 94.
Of the
section 47 application, which is GA number 2 of 2022.
94.
Page number 94. This is the decree.
Yes, 94.
Now, Millard, I have played the live stream, YouTube live stream last evening, and I have heard what and seen what happened on that day. A very pertinent question fell from your lordship, that is this decree, Millard, was liability created, Millard, jointly and severally on
Yes.
both the, that was a very pertinent question. Now, this is the decree, page 94. My lord, may kindly see that the last 4 or 5 lines of the first paragraph, that Ravi Shankar Ramachandran, I am on the 4th line, my lord. Ravi Shankar Ramachandran, defendant, respondent, and my lord, defendant, sum number 2 is Sam and Arun Subbarao Shetty, which is the defendant number 2, do pay to the plaintiff petitioner Bamalori of Bamalori and Company a sum of rupees 4,45,42,894 and paise 98 only, and the application being GA number 1035 of 2018 is allowed and
disposed of
accordingly. So, my lord, liability was created jointly. There was no reference whatsoever, there was no indication whatsoever that liability was sought to be created jointly and severally. Now, your lordship knows this proposition of law much better than what I do, that a judgment, my lord, cannot be dissected. Liabilities out of a judgment and a decree, my lord, cannot be dissected in law. Now, my lord, on that day, my lord, Order 21, Rule 2 was, my lord, shown by the defendant number 1, the judgment data number 1. My lord, may kindly, my lord, I allude beg to allude, my lord, Order 21.
Order 21.
Order 21, Rule 1, my lord, was alluded to by the other side.
Please.
Now, just 1 second, my lord. Now, may I place Order 21, Rule 2? This has absolutely no application whatsoever in a case like this. Payment out of court to decree holder. Because in this case, my lord, the judgment debtor number 1 has said that on his own, without taking the leave of the court, they have paid certain amount to in favor of the decree holder. And this is admitted position, my lord, that the judgment debtor number 1, my lord, is in employment, is in gainful employment under the decree holder. And it is also an admitted position, my lord, that at this stage of Order 12, Rule 6 proceeding, my lord, judgment upon admission, the defendant number 1, who is now the judgment debtor number 1, my lord, was enjoying my trust, and he filed the affidavit on behalf of himself as also myself. And he has since betrayed my trust. Now, my lord, they have made payment on their own of certain amount to and in favor of the decree holder. Now, whether or not this can at all be resorted to, Order 21, Rule 2, payment out of court to decree holder, where any money payable under a decree of any kind is paid out of court. Now, or a decree of any kind is otherwise adjusted in whole or in part to the satisfaction of the decree holder, the decree holder shall certify such payment of adjustment to the court, whose duty it is to execute the decree, and the court shall record the same accordingly. Well, this is a case, well, this proceeding, well, this provision, my lord, is applicable to a case where there is one decree, one judgment debtor, or where, my lord, a liability has been created, my lord, jointly and severally upon both the judgment debtors. Now, my lord, in this case, my lord, this has absolutely no application, because there is no application made by them. There is no certificate given by the decree holder in favor of this person. No application has been made, no formal application has been made by the judgment debtor number 1. So, my lord, today, tomorrow, or the day after, if somebody challenges my lord's order before the court of appeal, before the appeal from order court, there would be nothing on record to substantiate on what basis, my lord, this order was passed. Now, my lord, that is precisely why, my lord, I am telling you, lordship, that, my lord, they misled this honorable court, and unfortunately, we kept mum, my lord, while this order was passed. Now, my lord, and this prayer was made in the teeth of my application under section 47 of the Civil Procedure Code. So, my lord, I would not do what they have done. I would make a formal application for recalling of this order, particular order. My lord may decide it one way or the other. So, my lord, kindly.
We have come from district court and we know. And
Yes.
so I have asked the learned advocate of the decree holder as well as
Yes.
judge number 1 to
Yes.
file appropriate application.
Repeatedly, your lordship said that repeatedly.
Yes, my lord. And my lord, to that we had
When
what the
learned counsel of the decree holder, that application was not brought.
no, my lord.
Yes.
I being for the council.
Okay, the learned counsel of decree holder, whatever it may be, you may file
Well,
appropriate.
we had mentioned to the court that the terms of settlement has been executed and we will make an application appropriately.
Whatever it will
Which,
not.
to which my lord had agreed and my lord had directed us to come up with an application
I have
sometime thereafter.
you, but you have you did
Yes,
not.
sir. We are. Well, it is being the application is made ready. The person who is to sign is traveling. That is the reason why we could not come up with an application.
Okay, you please come with appropriate application.
Application, yes, my lord.
But this order just recorded the amount which has been paid.
Now, my lord, may I just tell you, lordship, one more? I will just take one more minute of my lord.
Means, Mr. Chakraborty, what does it term severally means? Will you please clarify me severally?
Yes, when this order, when a decree is passed jointly or severally, my lord, I can't hear you, lordship, my lord. I'm so sorry.
Jointly as well as single.
Yes.
Is it correct?
Yes, yes, yes.
Then
Now, my lord, there is.
I want to see your application first. Okay.
And I will physically appear before your lordship because there is some problem in, my lord, in transmission.
In Calcutta, there is no problem. In West Bengal, there is also no problem. So please come.
No, my pleasure, my lord. I will go. May I just tell you, lordship, one more thing, my lord, just one more thing. What is the impact? What is the fallout of this order? What was the conspiracy made for? May I just?
Your origin is from Kolkata. And also from this High Court.
Absolutely, absolutely correct, my lord. Absolutely, my lord. Absolutely, your lordship is. My lord, I am grateful, my lord. Just only one small thing, my lord. Lordship, may I just tell you, lordship, one small thing, that why was this conspiracy hatched between the decree holder and the judgment debtor number 1, and what is going to be the effect of it? Now, my lord, his bank account has been defrozen. So, my lord, he will, my lord, empty his bank account. The property which was being held, the ownership of the property which is being held by the judgment debtor number 1 and his mother, who is not a party to the suit, that property will also be sold because status quo order has been removed. And then, my lord, the entire liability will be sought to be foisted on me. Whereas, but that is the intention, that is the ulterior motive with which, my lord, this prayer was made and how this order, my lord, they tried to mislead this honorable court. So, my lord, I will.
In presence of you.
Now, my lord, that is the unfortunate aspect of the matter.
Cannot go. Okay. The learned counsel for the judgment debtor number 2.
2, yes.
Has submitted that the order dated February 13, 2024 has been procured.
No, lordship may not write that word, my lord. I was my lordship may not write that word, my lord.
May I beseech my lord for this much indulgence, my lord? Please record this.
Let my lord pass the order. Why are you disturbing? My lord is in the process of passing the order. Why are you disturbing?
With my lord's leave, my lord, only this much, my lord. My learned senior friend has mentioned they did not wish to file a reply to the application.
Judgment
Kindly record this.
Yes,
judgment
yes.
number 2 has submitted that the uh, uh, the uh, that the order passed on 13 February 2024 goes against the interest of the of his client, Learned Counsel বলেছি তো, of his client, and as such he wants to file an appropriate application for recalling the order dated 13 February 2024. Stop. The
Aye.
Learned Counsel for the judgment data number 2 has also submitted that he has instruction that his client will not file any affidavit in reply in respect of GA
Number 2.
2000 in respect na in GA 2 of 2023. Stop. Para. The Learned Counsel for the decree holder has submitted that the order dated 13 February 2024 has been rightly passed by this court. Stop. Least matter when, Mr. Chakraborty,
My lord, my lord,
after 7 days,
after 7 days on a Friday, my lord, may kindly keep it on a Friday.
Friday দেখো তো 29th is a very good day, auspicious days.
29th, do we have any? अरे वो तो बुधवार और बृहस्पतिवार है अपील.
First March.
Uh,
1st March.
Very well, my lord. First March. Very well.
I'm deeply obliged, my lord.
I am obliged too, my lord. I'm grateful.
দেখছো কিরকম
It's a pleasure, my lord, appearing with your lordship, my lord.
Okay, thank you.
Passed over matter, item number 2.
My lord, I am for the
Yes.
decree holder,
Decree
my
holder.
lord, that
Legal heirs issue.
Yes.
All the legal heirs appeared today. Then we have to add all of them.
It's not required to be, my lord. Lordship is aware under the Civil Procedure Code in execution, my lord, they are not required to be added. They are appearing. Let them make the application, my lord, for
Where?
mutation.
May I submit, my lord?
Other two advocates. তোমার ডেকে ডাকবে তো
ঘোষ, my lord.
চলে গেল they want to appear then I cannot reject them their prayer.
My lord, if
They
your
will
lordship
hear,
is
my lord. This is-
yes.
I mean,
The Learned Counsel for the
Mr. Chaudhary came in, he talked to me.
yes,
Can't
he
be
was
appeal.
sitting here. The matter was called left, then and there I saw. My lord, may I make a submission, my lord? My lord, as Mr. Ghosh, Devnath Ghosh was appearing and on behalf of the son, my lord, I have already, my client has already applied for the original death certificate of the KMC, my lord. This is the receipt, my lord. He is supposed to get the original death certificate on 29th of February. That the date has been given.
no, there is no dispute that the person died.
No, there is no dispute, my lord.
Then-
In the last occasion, we also submitted that we don't have any objection in the event the son's name is being mutated. Now, I cannot say on behalf of the others, my lord.
Okay.
They were representing, and one
But
was submitted, my
but
lord.
I asked you to file an
My lord,
affidavit.
that is why I'm,
Who are,
my
who are the legal heirs?
my lord, if my lord takes up my affidavit in opposition, my lord, on the first page, I have already declared who are the legal heirs, my lord.
Only
In the
3.
event, my lord,
Yes, only 3. There is no dispute about that.
I have already indicated that there are 3 legal heirs, my lord. In the event, my
So I
lord,
can ask the corporation to mutate their
Absolutely.
names.
Kindly direct that, my lord.
I have no difficulty in the event my name is recorded, my lord. I
Why
can
is
say for the others.
other sides? The daughter and son, daughter and wife. উনি একটা কি রেফার করছেন উনি affidavit in opposition. Please refer to your paragraph.
Kindly take up the affidavit in opposition, my lord, on the
By Abdullah Yusuf, kindly take up the affidavit in opposition filed by Abdullah Yusuf, my lord, my learned friend's client.
Yes, Abdullah Yusuf.
Kindly come to page, sorry, page 2.
Yes.
I have
Stop. So that match can be done.
that much
Yes.
can be.
Okay.
Yes. Kindly direct corporation to mutate the property in their name. And my lord, kindly keep the application pending.
But they want to know the particulars of the and who will pay the area taxes or something like that. That has to be done. Otherwise, mutation cannot be done. Otherwise, mutation cannot be done.
I mean, then okay.
They are not taking the liability, we'll take the liability subject to development.
Who will pay the area
My lord,
taxes?
in terms of, my lord, the agreement, it is for them to, my lord, get the property mutated. Till the mutation is completed, my lord, it's their liability. I can, to cut short the matter, my lord, I can pay it.
No, but I don't
Cannot
have
be
it.
recorded here. You will pay on their behalf. It cannot be recorded in the court's order. Can it be? It should not be.
কত আছে?
Liability কিছু নেই,
The NOC
up to date it's been
Oh.
paid.
It's up, paid up to date.
Okay, then
Anything is
yes,
liability.
kindly.
There is no liability.
Yes, your name is being recorded.
And the advocate report is Sriparna Das.
No, the name of
Name of the
deceased wife. Okay, and daughter.
Daughter was my lord represented my lord.
Zishan was appearing.
The learned counsel for the parties are present. Stop. The learned counsel for the judgment, the son. পুরোটাই কেটে দিন। The learned counsel for the son, wife and daughter of the deceased Nawab Yusuf are present. Stop. The learned counsels for the wife and daughter of the deceased have undertaken to file Bhokalatnava in course of the day.
Some more time. my lord.
In course of the day,
in course of tomorrow, my lord.
in course of tomorrow. In course of tomorrow. Stop.
My lord, this week, my lord, kindly, my lord. Old lady, my lord, she's suffering from many ailment. my lord.
In course of this week. Stop. The learned counsels of the decree holder as well as the learned counsels of the legal aids of the deceased Nawab Yusuf have submitted before this court that they have no objection if the names of the legal heirs of the deceased as mentioned in para 1 of affidavit in opposition filed by Abdullah Yusuf, son of late Nawab Yusuf, are mutated in the records of Kolkata Municipal Corporation. Stop. Para. Now, who will be directed on behalf of KMC? Who will be the respective officer?
Direct the KMC, my lord, and its appropriate authority officers.
KMC.
Lordship, I am appealing for the Kolkata Municipal Corporation, Lordship.
Yes.
The assessor collector may be directed, Lordship, or the chief manager, Revenue North.
North
The,
হবে না।
the learned counsel appearing on behalf of KMC has submitted that the assessor
Collector.
assessor hyphen collector any borrow or anything
No,
like
no,
that.
no. The easy, my lord.
Lordship, there is South and North Division, Lordship.
Yes,
South should be.
South Division.
Lordship, it will be come under North, Lordship.
North, sure. North Division.
Lordship, take it.
North Division, Kolkata Municipal Corporation may be directed to complete the mutation process. Stop. Para, in view of the above, the assessor collector, North Division, Kolkata Municipal Corporation is requested to mutate the names of the legal heirs and representatives of deceased Nawab Yusuf after complying with all the legal formalities. In respect of which property?
Yes, well, 5 Outram Street, Kolkata, my lord.
এটা লিখতে হবে in respect of property. Mutation in respect of
5B
property.
Outram Street, Kolkata.
না, এটা অ্যাড্রেসটা নিয়ে নেবেন, হ্যাঁ, অ্যাড্রেসটা নিয়ে নেবেন। Okay. After complying with all legal formalities, that means if anything is to be paid, you have to pay.
Yes.
Anybody else? I do not know. Okay. Anything else, Ms. Sengupta?
My lord,
No,
kind-
Lordship.
kindly, my
Lordship, I am also confused about now north and south because
Purely if it
Lordship can direct the concerned assessor collector, Lordship.
assessor collector.
ওটা কেটে দাও, the concerned assessor collector.
And my lord, within a particular time, fortnight or whatever it is.
Within
because-
1 month, within 1 month.
Within 1 month. Because my lord, I will get my original death certificate only on 29th of February. So
Okay.
I will need 10 days time for
Within 1
doing
month.
that, my lord.
And
Lordship, only that they have to submit the original death certificate.
The, pardon?
upon notice to the receiver, because the receiver has to take steps.
Notice will be issued by assessor collector.
On completion of the assessment or the recording, my lord, mutation, he will, my lord, inform the receiver.
And how he can know who is the receiver?
He
Intimate
was following.
report me.
He was following, my lord.
He should send a report to this court that
Correct,
mutation
correct.
was that will be
Lordship, after the mutation, I shall file the report before the court, Lordship.
guided counsel for the KMC will submit an appropriate report after process of mutation is over. Stop. The guided counsel for the son of the deceased Nawab Yusuf is to submit the original death certificate to the assessor collector by 5th March. Okay, you have to submit by 5th March.
I give not with the municipality.
Yes, assessor collector.
Assessor collector.
Okay. Anything else?
My lord, a short affidavit in opposition on behalf of the wife of the judgment debtor, my lord.
You may file, but against who? Against which? This is a different process.
They have, I have received the papers, my lord.
Okay.
The son has filed.
You are at liberty. You are at liberty.
Kindly permits me also to file a short affidavit. I'm still
Against which? Again, application means
my learned senior friends.
okay. You file a vokalatnama, then I shall I shall give you liberty. Okay. Let a copy of this order be communicated to the concerned assessor collector.
Yes.
Okay.
They are appearing, but we shall কি দরকার থাকে communicate করো না।
কে দেবে? হ্যাঁ? When? After 1 month বলেছি তো।
Yes.
After 4 weeks করে দিই? Returnable, list the matter after 4 weeks. Okay. That's all.
I'm grateful, my lord.
তার মানে তাদের উপরে করতে হবে না 5 weeks হবে হ্যাঁ বলে দিতে
ঠিক আছে 5 weeks করে।
তাই তো 5 weeks হলে হচ্ছে 27 তারিখ করে 27th March 27th March হ্যাঁ item number 7
Your Lordship, I appear for the degree holder.
I'm for judgment debtor, my lord. My lord, from last 2 times they have taken time to file application, but still that time they did not file any application.
Your Lordship,
What is the case about?
Your Lordship, it is related to the mean profit, Your Lordship. We have obtained a degree The installments have been paid, but according to us, Your Lordship, one installment has to be paid. Their contention is that all installments have been paid. So we have taken out an application for modification of the tabular statement, Your Lordship. The same will be filed within the course of the day, Your Lordship. There was some
Come back at 2 p.m. Hey, দুটোর সময় রাখো। Come back at
Your
2
Lordship,
p.m.
today it's being affirmed, Your Lordship. Today I just
So
have to,
tomorrow, not today করে দিন।
yes, Your Lordship.
Not today.
Grateful, Your Lordship.
Item number 8.
I appear on behalf of the intervener.
My lord, if your lordship recalls, on the last occasion there was a direction upon us to serve a copy of the execution case upon my friend. My lord, I have done that. May I just tender my affidavit of service, my lord? That may be taken on record.
Yes.
Today, my lord, your lordship would decide if they have any right or not, and accordingly, my lord, pass a final order.
Lordship, may I first place Order 21, Rule 97 of CPC
এই এটা নোট করতে
to
হবে।
show my right to intervene.
Order 20.
1 Rule 97. If I am the person who is in possession, actual physical possession of the property, the decree is against one
Order
Deepak
20.
Tarachand who had sublet this property to me, and I am the one who is in actual physical possession, though the decree is against the judgment debtor. Lordship, I'll have to prove my locus standi to file this application and be intervened, added as a party. Lordship will see Order 21, Rule 97, resistance or obstruction.
What is the name of your client?
Lordship, Tamal Banerjee.
Tamal Banerjee. Intervener. Proposed intervener.
Proposed intervener, Your Lordship, as of now. Your Lordship, Order 21, Rule 97 states resistance or obstruction to possession of immovable property, where the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person obtaining possession of the property, he may make an application to the court complaining of such resistance or obstruction. Subsection 2 is where any application is made under subrule 1, the court shall proceed to adjudicate upon the application in accordance with the provisions herein contained.
So you have filed that petition.
If I have filed my application, the only apprehension that I apprehended was that here this section states that the holder of a decree may make an application. But if I'm carrying a judgment which states that since the word any person is used, a person who's in actual physical possession can also, a third party can also make an application.
A third party can also
make an application. The
yes, judgment.
1998 4 SCC.
1998 4 SCC.
543.
Yes.
Paras 10 and 11.
Yes.
I've given a copy to my friend. The Lordship kindly comes to para 10. Under subclause 1, Order 21, Rule 35, the executing court delivers actual physical possession of the disputed property to the decree holder, and if necessary, by removing any person bound by the decree who refuses to vacate the said property. The significant words are by removing any person bound by the decree. Order 21, Rule 36 conceives of immovable property where in occupancy of a tenant or other person not bound by the decree, the court delivers possession by fixing a copy of the warrant in some conspicuous place of the said property and proclaiming to the occupant by beat of drum or other customary mode at some convenient place the substance of the decree in regard to the property. In other words, the decree holder gets the symbolic possession. Order 21, Rule 97 conceives of resistance or obstruction to the possession of immovable property when made in execution of a decree by any person. The word used in the section is any person. This may be either by the person bound by the decree, claiming title through the judgment debtor, or pers- or claiming independent right of his own, including a tenant not party to the suit, or even a stranger. So, Lordship, even a stranger who is in actual physical possession, which is admitted that I am the person who is in actual physical possession of the property, can make an application in the execution under Order 21, Rule 97. And Your Lordship, subsection 2 states where any application is made under Subrule 1, the court shall proceed to adjudicate the application in accordance with the provisions. So, Your Lordship, the word uses shall proceed to adjudicate. So, Your Lordship, subject to
Sir, I'll cut
correction-
it very short. I'm not on joining
helping
issue
him
here.
or-
I'll cut it very short, my lord. He has come before the court saying that he's in possession. My lord, he has a right to file an application if he's in possession. My lord, let him show that he has a right to remain there, because, my lord, application is, my lord, on the basis that he has a right. Let him show he has a right. Locus, my lord, locus is never under challenge. If the receiver said in his report that my friend is in possession, of course he can come and file an application. The question is how much merit will that application
He
have?
wants to know whether I know this law or not. That is the duty of the advocate also. That
Very
he should inform the court that this is the present law.
Very,
That is he is doing.
very well, my lord.
So,
It may just cut.
I'm doing this from 96. Please tell me once again. I know the third party
This
has
is-
right, stranger has right to agitate this.
Very, very elementary.
And why these provisions have been made? So that you cannot make a separate suit.
fresh suit, Your Lordship. The paragraph
To
11 of
help the decree holder,
Lordship.
not you. To cut short the matter,
Lordship.
the law has provided no separate suit is needed.
Required.
Okay, I know
Lordship, I just paged it out
Okay,
of abundant
okay.
caution.
you have done your duty.
Your Lordship, we've been served pursuant to Your Lordship's last order. We've been served with an execution petition. Now, Your Lordship, may kindly take up the execution petition one.
Execution petition to the yes.
Your Lordship will find from the tabular statement. Lordship, annex at the top.
Yes.
Lordship, the date of the decree, which is the third column.
6 September
6
2010.
September 2010, Your Lordship.
Yes.
And Your Lordship will find this execution application has been affirmed on 24th of April 2023.
Execution case filed
On 24th of April 2023.
20
4th of April 2023.
13 years.
13 years, Your Lordship. Page 8 is the affirmation. 13 years later after getting the decree. Your Lordship, may kindly take up Article 137 of the Limitation Act.
Huh. One
137. Lordship, my learned friend was on the previous occasions harping on the urgency. The decree was of 2010. They woke up and filed this on 2023. As such, there is no urgency to take over the possession immediately. Heavens will not fall if it's not done after hearing me.
3 years. Any other application for which no period of limitation is provided elsewhere in this division. So
Your
there's
Lordship,
no-
136. I'm extremely apologetic, Your Lordship. 136. For the execution of any decree other than a decree granting a mandatory injunction or order of any civil code, 12 years. When the decree or order becomes enforceable, or where the decree or any subsequent order directs any payment of money or the delivery of any property to be made at a certain date or at a recurring period, when default in making the payment or delivery in respect of which execution is sought takes place, provided that an application for the enforcement or execution of a decree granting a perpetual injunction shall not be subject to any period of limitation. Your Lordship, 12 years. 6 September 2010, the decree was passed. 6 September 2022, 12 years expires. Now, Your Lordship, in the execution petition, my learned friend has inserted one paragraph for limitation. Your Lordship may kindly take up page 7 of the execution petition.
Page 7.
Page 7 of the execution.
Affidavit.
Yes, Your Lordship, affidavit supporting the tabular statement. Paragraph 18.
Para 18.
Para
Yes.
18. My learned friend seeks to claim benefit of the Supreme Court order passed during the COVID times. We say that in terms of the order dated 10th of January 2022, passed by the Honorable Supreme Court, a copy whereof is annexed here to the period from March 15, 2020 up to February 28, 2022 stands excluded in computing the period of limitation. The execution case is well within the period of limitation. None of the reliefs are barred by limitation. My Lordship, he annexes the Supreme Court order. In my respectful submission, even if given the benefit of the Supreme Court's order, this execution petition is beyond time. Lordship may kindly take up page 29 of the petition.
Yes. Page
29 of
Of-
the petition, of the affidavit supporting the tabular statement. The Supreme Court order on COVID.
Yes.
Should my learned friend claims benefit under that, but Your Lordship may kindly come to page 31 directly, paragraph 5, which is the relevant paragraph. I shall endeavor to show Your Lordship that my learned friend, even after the benefit given by the Supreme Court order, does not fall within the, is barred by limitation. So I'm reading 5, part 1. The order dated 23rd of March 2020 is restored, and in continuation of the subsequent orders dated such and such, it is directed that the period from 15th March 2020 till 28th of February 2022 shall stand excluded for the purposes of limitation as may be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. Now, Your Lordship may kindly take 2, which I am relying on. Consequently, this is after 1. The balance period of limitation remaining as on 3rd of October 2021, if any, shall become available with effect from 1st of March 2022. So whatever was the balance as on 3rd of October 2021, my learned friend will get the benefit on and from 1st of March 2022. So Your Lordship, decree of 6 September 2010, 3rd of October 2021, Your Lordship, the actual balance period till 6th of September 2022 was 338 days. Your Lordship, I have done the calculation. If my learned friend has any objection, he can always come before Your Lordship. So from 1st of March 2022, Your Lordship, my learned friend had another 338 days. In normal course of things, it would have expired on 6th of September 2022. But since the Supreme Court has provided for this, from 1st of March 2022, my learned friend has another 338 days, which then expires on 2nd of February 2023. And this application has been affirmed on 24th of April 2023. So even after giving the benefit of the Supreme Court's order, Your Lordship, my learned friend is still out of time. I hope I'm been able to explain myself.
My lord, may kindly just inquire, my lord, whether my friend is calculating from the date of the judgment or the date when the decree was drawn. My lord, that's a distinction, perhaps, which may be handy.
You will get
Decree can be drawn.
opportunity.
Decree has to be drawn up within 7 days.
So we'll start from
The date of the judgment.
from 1/3/2022. Yes.
Which is the date of the decree in his tabular statement is 6 September 2010. And Your Lordship, any party, any decree holder can apply for a decree even later. The rule provides within 7 days. Now, if he applies after 1 day, after 1 year, and then he says that from the date of when the decree is drawn up, from there the limitation will start, it is not so. It will start from the date the judgment was delivered, subject to correction, Your Lordship. There is a provision that Your Lordships can condone. I can come after 1 year and ask Your Lordships to allow me to draw up the decree. Your Lordship, in your Lordship's, in the interest of justice, your Lordship will allow him to drop the decree after 1 year upon payment of such costs or whatever your Lordship deems fit. But that does not extend the period of limitation.
136 says the term the decree.
Lordship, for drawing up of decree.
Decree or order becomes enforceable. Why
Lordship.
the decree? The term is used as decree. Okay, whatever.
Lordship, according to the tabular statement, also the date of decree 6 September 2010, and that will be the, your Lordship may kindly appreciate, he can apply for drawing up of decree after 5 years, like he has applied for execution after 12 years. That is his choice. That does not extend the period of limitation. Lordship, it's like applying for certified copy. Your Lordship had passed an order today, I have applied after 10 days for certified copy and then say that my period of limitation starts from the date I have. Lordship, that cannot be
The
the
basic concept of when the limitation will start to run, then
Lordship. So it's from 6 September 2010 that the period of limitation
Yes.
starts to run. So even after giving the benefit of the Supreme Court's order,
your contention this is a date of decree.
yes, your Lordship, date of
Limitation will
decree
start from date of decree. This is your
Lordship.
contention. That is 6
6 September 2010.
10.
So if that be so, the present execution petition is time barred, even after giving benefit of the Supreme Court's order.
6/9/2020, 2010, and it will come to an halt in 15/3. 15/3.
Your Lordship, 15/3.
2020.
No, Your Lordship. Your Lordship.
So
if
what is your contention? It will
Your Lordship will see the Supreme Court order again.
why 338 days?
Your Lordship may kindly see the Supreme Court's order once again.
Yes.
Lordship, ordinarily it would have expired on 6 September 2022, 12 years.
Yes.
Now, Your Lordship, my learned friend is claiming benefit of the Supreme Court's order.
Yes.
Supreme Court's order on limitation. Lordship may kindly take page 32 of his affidavit. What has the Supreme Court given benefit of? Page 32.
32.
Roman 2, Your Lordship. Consequently,
Huh.
the balance period of limitation.
What does it mean, this balance period of
Your Lordship, balance period of limitation in the sense this was expiring on 6 September 2022.
Yes.
So the balance period of limitation as on 3rd of October 2021. So as on 3rd of October 2021, the balance period till 6th of September 2022 was 338 days. From 3rd of October 2021 to 6th of September 2022. That is the balance period of limitation that my learned friend was entitled to. Was 338 days. Your Lordship, I have done my calculation. 338 days. If any, shall become available with effect from 1st of March 2022. So whatever be the balance period as on 33rd of October 2021 will become available with effect from 1st of March 2022. So this 338 days will again be my learned friend will enjoy the benefit from 1st of March 2022.
So he has to file should have filed the petition within this 338 days.
Within these 338 days, which is expiring on 2nd of February 2023. So 1st of March 2022 plus 338 days takes your Lordship to 2nd of February 2023.
Yes.
2nd of February 2023, the clock stops. After that, if he files the execution petition, it is time barred. He has affirmed it on 24th of April 2023. And Lordship, it's not just this delay. Your Lordship may kindly appreciate a decree of 2010. He's been sleeping over it for more than 12 years. And now he's acting as if this heavens will fall if this decree is not executed. This is one of the grounds. Now, Your Lordship may kindly take up the decree. Your Lordship, not the decree. Your Lordship, I preferred an Order 9, Rule 30. Single bench dismissed it. I preferred an appeal therefrom. May I place that order of the appeal court? Your Lordship may kindly take up my application, GA1.
HG1. Intervener previously intervened.
Lordship.
In which process? In the suit?
Yes, Your Lordship. In the suit, I had intervened. I was directed to be added as a party. Good, bad, indifferent. My client did not take steps, nor did the plaintiff take steps to get himself added.
Yes.
Your Lordship may kindly take up the decree, the page 17 of my GA application. This is an order dated 16th of August 2011.
Page number?
Page 17 of my application.
Yes.
Also, page 17. This is a division bench's order appeal from an order rejecting my order 9 rule 13. Rejecting my order, my application under order 9 rule 13 of the Code of Civil Procedure.
Yes.
Your Lordship, I'll just place the first paragraph so that Your Lordship gets the background of the facts. Instead of hearing the application for stay, in connection with this appeal, preferred against rejection of an application under Order 9 Rule 13 CPC passed by learned single judge of this court, we propose to hear out the appeal itself as the learned counsel for the parties have advanced their arguments on merit. This was an appeal from an order rejecting my Order 9 Rule 13. My Lordship, the only line I wish to place before Your Lordship is page 90. Page 19, second paragraph. We are unable, this is the division bench's finding, we are unable to approve the finding of the learned single judge that it was the duty of the third party to amend the plaint by incorporating his name as defendant. Once the application for addition of party was allowed and the said order was not challenged by the plaintiff, it was for the plaintiff to add the third party in the proceeding as an additional defendant. This is a division bench's finding on the proposition that my learned friend was asserting on the last occasion. So it was the plaintiff's duty to add me as a defendant. Now, Your Lordship, the next line is more important. Be that as it may, as no decree has been passed against Tamal, that is the intervener before Your Lordship, but the decree is restricted against Deepak Tarachand alone. In our opinion, the learned single judge, instead of entering into the merit of the application, should have dismissed the said application on the sole ground. Lordship, so the decree, the observation that the decree is restricted only to the judgment debtor. Because though I had made an application for intervention, I was added as a party. The plaintiff did not take steps to add me as a party. Hence, I was not added as a defendant. So the decree today as it stands is limited only against Deepak Tarachand. Now, today, I, who is in actual physical possession of the property, subject to correction, the decree cannot be executed against me. If today Deepak Tarachand was in the possession of the property, he could have been removed. I being a sublet, I being a Your Lordship, sublet.
What would be the status?
Your Lordship, not the status, the word. Person who is in possession of the property, Your Lordship, if I may put it so.
Not trespasser.
Lordship?
Not trespasser.
Not trespasser, Your Lordship. I was a subleasee. Your Lordship, I'll show my third leg of the argument is still left. Why this suit came before Your Lordship? Lordship, I will address Your Lordship. That's the third leg of my argument. So a person who's in possession of the property and is not the judgment debtor cannot be removed while executing this decree. Because this decree is restricted to the judgment debtor, that is Deepak Tarachand, who is not in actual physical possession. So today, I cannot be evicted on the basis of a decree passed against someone else who is not in actual physical possession of the property. Because the division bench has clearly recorded that this decree is only against Deepak Tarachand. And there's a clear finding that the plaintiff ought to have amended the plaint. Now, Your Lordship, may I come to the third leg of my argument? Lordship, my GA application, Your Lordship, this was drafted I must admit, this was drafted very shortly because I did not have all the papers. Your Lordship had given me only 5 days time to draft it. So from whatever I could gather, Your Lordship, I've made an application so that I can at least have an audience before Your Lordship. Now, Your Lordship, may kindly take up my application.
What is that? GA?
GA1.
Yes.
My case is The decree holder today before your lordship, someone Mr. Surana, his predecessor in interest. One Jeevan Parekh had the knowledge that I have been sublet. Because at the time I had entered this property, Mr. Jeevan Kumar Parekh was the one who was looking after the property. He knew that the property was sublet to me. And your lordship, I have made that statement in my application. Your lordship will kindly take up paragraph 6 and 7 of my application. Why this suit came into being. Now the judgment debtor, which is Deepak Tarachand, at that point of time was trying to illegally dispossess me. It was all hands in glove. As a result of such attempts by the judgment debtor herein, I am placing paragraph 6 of my application. The applicant herein was constrained to institute a suit before the Learned City Civil Court at Calcutta. That is the intervener before your lordship. I had filed a suit against the judgment debtor herein, Deepak Tarachand, not to dispossess me illegally and without following due process of law.
Who inducted you there?
Your lordship, I was inducted by Deepak Tarachand, who was the tenant. I was the subtenant, with the consent and knowledge of the then landlord Jeevan Parekh. I file this, they try to dispossess me. I file a suit saying, please do not dispossess me without due process of law. In response, what did the judgment debtor do? The judgment debtor, as a counterblast, had instituted a suit for eviction against me of the applicant herein before the City Civil Court, which was decreed on 18th of July 2001. This suit is in 2002, your lordship. Your lordship, I'm just trying to draw the timeline. The Learned City Civil Court.
Who was judgment debtor? That is a Jeevan Parekh, or?
Yes, your lordship. Deepak Tarachand, who was my, your lordship, not my landlord, but under whom I was the subtenant.
He
had filed an eviction suit against me. He had filed an eviction suit against me. So he had acknowledged that I was a subtenant under him. I suffered a decree. I went up in appeal, wherein the High Court at Calcutta passed an order dated 4th of October 2001, wherein this decree was stayed. So all these attempts were being made to take me out of the property. Now I suffered a decree, but somehow in the appeal, I was safeguarded by this High Court. The decree was stayed. No further steps thereon. When they see that this decree has been stayed and they cannot take me out of possession, they file the instant suit in 2002. This suit, pursuant to which this execution has been filed.
Who filed this suit?
This was filed by the superior landlord against Deepak Tarachand, even when Deepak Tarachand had instituted a suit of eviction against me, where unfortunately, for my client's fortune, but unfortunately, Deepak Tarachand suffered a stay. So when their hands were tied, the decree was stayed, they could not get me out of the property, they come up with this suit, wherein the superior landlord sues the tenant, but does not make the subtenant a party. So Mr. Surana sues Deepak Tarachand, does not make me a party.
Now, whether there's an agreement that sublease can be created,
your lordship,
sublease can be created.
Your lordship, there was no agreement. But your lordship, the then landlord, your lordship, I've pleaded. I'll have to fish out documents. I am not denying that. Your lordship, this was very.
Then why the superior landlord will add you as a party? Why?
Your lordship, he did not. That is why I had.
Now, why? He has no knowledge that sublease has been created.
No, your lordship, he had knowledge. I've pleaded that he had knowledge.
How it can be proved?
Your lordship, that I'll have to come up with documents, I admit. Your lordship, this application was drafted within 5 days. Your lordship had given me only 5 days to draft it. So whatever documents I had, I have prepared an application and come before your lordship. Otherwise, your lordship, I would have been out of possession by now. Your lordship, I had to come up with some application. Your lordship, I had already indicated the person who's in actual physical possession is a mechanic who repairs generators. He's not a well-read person. So, lordship, it's been a task for me to take out these papers.
Okay, I'm hearing you. I have no problem.
So, your lordship, basically what I wanted to portray to your lordship is that first the judgment debtor, which is Deepak Tarachand, who was the original tenant, sues me for eviction, suffers a stay, cannot get me evicted. Then they come up with in 2001, and then they come up, the superior landlord and the tenant come up with another plan of this suit, which they file in 2002, between the superior landlord and the tenant, and do not make me a party and obtain a decree.
Next.
This is my third leg of argument, that this suit is nothing but an eyewash only to get me evicted. Since they could not get me evicted in the eviction suit, they have come up with this instant suit as a ploy to get me evicted. Your Lordship, my first point is my best point, that this execution petition itself is barred by laws of limitation. And once my learned friend's client has been sleeping over his rights for 13 years, today heavens will not fall if Your Lordship I have given a proper opportunity. Your Lordship, I would like to file another application bringing all the documents on record. Heavens will not fall if I come up with an proper application with all these documents before Your Lordship, so that Your Lordship can adjudicate. And Order 21, Rule 97 clearly says, sub Rule 2, that once an application comes before Your Lordship will have to adjudicate it. So at this moment, at this stage, Your Lordship, I would humbly be praying for two things. Lordship, let me be added as a party respondent in the execution, in the execution petition. And B, Your Lordship, till the time being, Your Lordship hears the application, Lordship may kindly not direct the receiver or the special officer to take possession of the property. After completely hearing me, if Your Lordship is of the opinion that no, I do not have any right, title or interest in the property, Your Lordship will pass necessary.
I was hearing you.
No, Your Lordship, this application, Lordship, that's why I was pointing out, this application was filed in a very short point of time. Lordship, I would request Your Lordship's leave to file another application with all the documents, or file a supplementary affidavit. Whichever way Your Lordship pleases.
No, this will just delay things further.
Yes. So he has no right to intervene.
He has
no right to intervene.
He has said that limitation is his best point. So my lord can imagine on merits, my lord, what kind of a case he would be having. Kindly hear me briefly, my lord. I believe, my lord, your lordship will be able to perhaps make a decision. After hearing me, if your lordship, my lord, thinks
you have
that
completed so far as this petition is concerned.
As of now, Your Lordship, yes. But Your Lordship may kindly grant me leave to file a supplementary affidavit to bring on
After
further
hearing them,
after
decree holder.
Yes. My lord, first on limitation or merits?
Limitation.
Right. My lord, kindly have a look at the execution case for a moment.
Execution.
Yes, my lord, the execution case. My lord.
EC. Yes.
My lord, and kindly, my lord, take. My lord, the judgment was passed on 6th September 2010. And the decree, my lord, was drawn on 10th August 2011. The decree, my lord, is at page 18. Kindly have a look.
Decree drawn.
Yes.
Date.
The decree, my lord, is 10th August 2011.
Decree was
yes.
6/9/2010. Yes.
Your lordship will kindly, my lord, have a look at the kindly, my lord, have a look at the at page 18, my lord. My lord, drawing of decree, my lord, in our court takes, my lord, some time, substantial amount of time. My lord, at page 18, if your lordship sees, 6th, yes, my lord, 6th, kindly bear in mind, my lord, the judgment, my lord, was of 6th September 2010.
Yes.
And now your lordship will kindly see page 18, my lord.
Yeah.
Yes. The decree, my lord, 9th September 2010, my lord, appears to be the date on which I applied. I have again cross-checked with my advocate on record, my lord. He would get back to me on this. But, my lord, my assumption would be...
Application for certificate copy?
No, my lord. For drawing the decree, my lord, once the judgment is passed, my lord, we apply within 7 days, as my learned friend pointed out, for the decree to be drawn. So that date, my lord, I'm assuming this is that date. It's there on top, my lord. 9th September 2010. Yet, my lord, I have cross-checked with my advocate on record. He will get back and confirm. And, my lord, it has taken, my lord, a substantial amount of time for the court to, my lord, draw the decree. And ultimately, my lord, the decree has come in August 2011. So only when I, my lord, get the decree can I, my lord, apply for execution. Without, my lord, a decree, I cannot apply for. What will I execute if there's no decree? A decree has to be drawn, my lord. Fundamentals, first principles, my lord, distinguishing a judgment from a decree. So this entire limitation thing, my lord, falls flat. Out of abundant caution, there was a pleading that yes, even the Supreme Court has said that for those 2 years of COVID, my lord, limitation would not be calculated. That is, my lord, supplementary. Even if I don't avail that, I'm through. Because it would start, my lord, from the date of the decree being drawn, and 3 days which I took to apply for drawing the decree, that would be counted. So from the 7th and 8th of September 2010, 2 days would be counted. And then, my lord, I will get 12 years less 2 days from the day I got the decree. So I'm through. Assuming, hypothetically assuming, my lord, that I applied for the decree to be drawn on the 10th of August 2011.
So 8/8/2023.
10/8. Yes. Yes, correct. Yes. Now, my lord,
You have filed in the month of April.
Yes. Now, my lord, hypothetically assuming, let's, my lord, say that I was best friends with the my lord, department, and I applied on the 10th of August 2011 for drawing up the decree, and I was given it the same day. Let's assume. Only then, my lord, would the time be calculated from the date of the judgment. If I applied for a decree in August and got it on the same day, only then, my lord, would my friend's calculation, my lord, lie, which is not the truth, because decree can never come in a day. My lord, even then, kindly see, my lord, from the date of the judgment also, if I calculate, the date of the judgment is 6th September 2010. COVID hit us in January 2020, and the Supreme Court, my lord, said that from 15th March. 15th March. I'm being specific with the date as well. 15th March. So from September 2010, 7th September 2010 till 15th March 2020, my lord, it takes me to 9 years, 6 months, 9 days. Because 10 years would be completed, my lord, in September 2020. We are talking about March 2020. So, my lord, 9.5 years. So I have 2.5 years remaining. 15th September, limitation stops running. 15th March 2020, limitation stops running until 28th February 2022. So from 1st March 2022, I have my balance period. It's greater than 90 days. That is 2.5 years, because I had only exhausted 9.5 years until COVID began. So from 1st March 2022, I have another 2.5 years, which would take me way beyond 2024. Even today, if I would have applied for my execution, I would have still been within limitation. It's very plain math. And this is assuming, Malad, my friend's argument. He has completely disregarded the fact when the application was made for drawing the decree and when the decree was ultimately given. Perhaps, Malad, my friend Malad, hasn't undergone that tedious task of having a decree drawn, Malad, from our court. It's more difficult, Malad, than actually having a suit, Malad, heard to, Malad, have a decree drawn. Very difficult in the department. And, Malad, several, Malad, factors, Malad, play a role in how expeditiously one can perhaps...
I'm always a judge. I do not know anything else.
Malad, kindly now, Malad, for a moment, Malad. Now, Malad, that this limitation, Malad, unless your Lordship, Malad, wants me to address further on limitation, kindly, Malad, let me show you, Lordship, Malad, their application which they have filed. Kindly, Malad, have a look. Kindly, Malad, take their application for a moment. Let us assume, Malad, for a moment that everything that they have...
This is clear to me that if a the suit is filed by a plaintiff.
Yes.
Now, if defendant's name is to be added.
Yes.
Who will make the suitable correction to the plaint?
My lord, the law requires, my lord, the plaintiff to make that correction.
Yes.
But the learned single judge, my lord, perhaps made an error by saying that no, the defendant will do the needful, which is why in my lord appeal, the appeal court clarified that. But I can't, my lord, go against the order of the court. If the court directs the defendant to do something, then he has to do it.
That is an order of single judge.
Order of single
That has
judge.
been clarified in division benches.
But division bench said that my friend didn't have. I didn't require to add my friend as a party. I will show those orders.
Okay.
I will show those orders. My lord, kindly, my lord, for a moment, my lord, assume. Or rather, may I clarify that doubt first? May I clarify that doubt first? Kindly, my lord, have a look. The learned single judge, my lord, I'll just summarize. I've placed this order on the previous occasion. The learned single judge said that they will file the written statement and make necessary changes in the records. My lord, now they went in appeal from that order, which I now, my lord, learned. Kindly, my lord, now see that order.
Which page?
Page 17 of their application. Order of 16th August 2011. Just 6 days after the decree was drawn.
Yes.
This is their second best point I'm dealing with. The best point was limitation.
GA1, no?
Yes. This is yes, my lord. GA1 of 2024.
17.
GA1 of 2024, my lord.
Yes.
Page 17, yes. Kindly, my lord, have a look at. May I, my lord, just place the relevant part of this judgment? Kindly, my lord, come to page 19.
Yes.
In our opinion, second paragraph, my lord. In our opinion, when in the suit, Tamal is, my lord, my friend's client. When in the suit, Tamal was ultimately not added for not taking step for amendment of the cause title. And in the decree, Deepak Tarachan being shown as the sole judgment debtor, the application for setting aside the ex parte decree was not maintainable at the instance of Tamal, although in the past he got an opportunity of being added as a party. So the division bench also holds, my lord, that Tamal did not have a right to have the decree set aside. Then, my lord, kindly see the next paragraph. Only on one point, the division bench, my lord, disagrees with the learned single judge. We are unable to approve the finding of the learned single judge that it was the duty of the third party to amend the plaint by incorporating his name as defendant. Once the application for addition of party was allowed and the said order was not challenged by the plaintiff, it was for the plaintiff to add the third party in the proceeding as additional defendant. Kindly, my lord, read further. These are, my lord, the subsequent lines are, my lord, something which my learned friend did not place before your lordship. Be that as it may, as no decree has been passed against Tamal, but the decree is restricted against Deepak Tarachan alone. In our opinion, the learned single judge, instead of entering into the merit of the application, should have dismissed the said application on the sole ground that a third party to a proceeding cannot maintain an application for setting aside ex parte decree unless he happen to be the heirs and legal representatives of defendant or the interest of the defendant has devolved upon him in course of the judicial proceeding as provided under Order 22 Rule 10 CPC. In the case before us, the position of the appellant before us is not that of the heirs or legal representatives of decree holder or that of a person who has derived interest in the property from the defendant during the pendency of the suit.
This is this line.
Yes,
he is saying that he's saying that he was inducted there as a
no, these are, my lord, these are, my lord,
that of a person who has derived interest in the property from the defendant
Yes.
during the pendency of the suit.
Yes, my lord, may I just place this again? Kindly, my lord.
Yes.
In the case before us, the position of the appellant before us is not that of the heirs or so appellant is my friend. He's the appellant, and the High Court holds the position of the appellant before us is not that of the heirs and legal representatives or the decree holder. So decree holder, I am the decree holder. He is not my heir or my legal representative.
Yes. Next line.
Or that of a person who has derived interest in the property from the defendant during the pendency of the suit. So he has, Deepak Tarachand was the defendant, and the High Court says that during pendency of the suit, my friend had not derived any
interest from Deepak Tarachand.
No, yes, exactly. This favors me.
Next.
There's a finding. We make it so, my lord. During pendency of the suit, nothing. Perhaps before pendency, something my friend may say there was something before the suit began. We make it clear that in view of our order, the position of the appellant before us is that of a third party to a decree.
Yes.
The order impugned is thus modified.
His status has been recognized as a third party to a decree.
Third party to a decree.
So in the execution proceeding, a third party to a decree can challenge, can take up the issue.
Of course, he's come today, but he has to show what documents he has to prove his right there. My lord, today I can also, my lord, be a fourth party to a decree. Your lordship can become a fifth party to a decree. Any one of us in this room, my lord, can just be outsiders to a decree, my lord. But that would not give us a right to, my lord, remain in the property.
Okay. Next.
We make it clear, kindly mark that, my lord. We make it clear that we have otherwise not gone into the respective claims of the parties in the proceedings. So the High Court, my lord, has not gone into any, my lord, insofar as, my lord, this proceeding was concerned to intervene, etc., my lord, it has been left open. Now, my lord, why the High Court said, I asked myself, my lord, why did the division bench say that his application to intervene could not have been allowed? Reason being, my lord, that I am the plaintiff, I know who I have a right against, and I decide whom to sue upon the advice, my lord, given to me by my lawyers. If I feel that I can get a decree against Mr. X, and getting a decree against him would assure the property coming to me, I will only sue him. If in law I deem fit that no, I must also implead Mr. Y as a party, then I will implead Mr. Y as a party. But if I have only impleaded Mr. X and get a decree against Mr. X, in the execution of the decree, if Y feels that he has an independent right, he can't have a right under X. Because if X has been asked to go, Y also, if he's claiming under X, has to go. He has to show that he has an independent right against me. And I should have sued him independently. That is what he has to show before the court. Kindly, my lord, now let's see if that has been done in this case.
But he has said that he has given only 5 days time. That's why.
But in 5 days, my lord, at least in 5 days, my lord, some person can perhaps say less things. He may add on things. But in 5 days, a person won't lie. What he has said so far in 5 days, at least that has to be true. He can't commit perjury just because he has 5 days. So let's go by what the pleadings are.
Yes.
Kindly, my lord, have a look. Kindly, my lord, have a look at their application. Truth, my lord, doesn't change. 5 days is less time, I understand. He can bring more documents. He can say additional things. He can add on. Instead of 10 paragraphs, it could be 40 paragraphs. But the 10 paragraphs, he can't today withdraw. He can't change his stance. He can't change his pleadings. Prima facie, what the client instructs is always the truth, my lord. Later, the lawyer uses his mind and then, my lord, tries to circumvent.
Add on. They also.
Kindly, my lord, have a look. Page 2, my lord. Kindly see.
Yes.
Paragraph 4.
Yes.
The said Jivani. Now, my lord, may I just give your lordship a brief background, my lord, of who am I and what is the property? Very, very brief, my lord, which will be evident from the execution case itself. Your lordship, my lord, need not see the papers for a moment. My lord, I am a trust. I own the entire property. This property was leased out to Jivani Parak. Jivani Parak. It was leased out. in my lord, the year 1970. Then in the year 1998, my lord, Jivani Parak died. And his heir, Lakshmipat Parak, my lord, stepped into the shoes of the deceased lessee. Then in the year 2000, the said Lakshmipat Parak surrendered the lease
To the trust.
to the trust. So in the year 2000, I got back the trust property, which is a ground plus 5-story building. In that building on the second floor, in one room, the trust realized that some person named Deepak Tarachand was there, who claimed to have been inducted by Jivani Parak. We had no knowledge, we had no information about this Deepak Tarachand. So in our records, he was a trespasser. So though the tenancy was surrendered, we got back the entire property. In one room, this trespasser continued to be there. So we sued him as a trespasser. Now, in this background, my lord, kindly now see who my friend claims to be. And the High Court, my lord, adjudicated, and it has thrown out Deepak Tarachand as a trespasser. My plaint also I have placed on record out of abundant caution. Separately, I had filed my plaint, my lord, to show what my stance in the plaint was. And in the plaint, I have disclosed my friend's name. That yes, Deepak Tarachand was the trespasser. And in that room, along with him, he had also gotten one of his friends, this person whom we do not know who he is. Tamal, complete stranger. Now, my lord, kindly see what he says. Kindly, my lord, have a look. Kindly see paragraph 3, my lord, of their application. Is my lord there? Yes. By registered deed of lease dated so-and-so 1970, the then trustees of one trust had demised the said premises to one Jivani Kumar Parak. 4. The said Jivani Kumar Parak had induced the judgment debtor. Had inducted the judgment debtor herein as a tenant in respect of the subject property with a further right to sublet the same. My lord, kindly mark this for a moment. Kindly, my lord, see that Jivani Kumar Parak inducted the judgment debtor herein. So, Tamal, the Banerjee, their contention is that Deepak Tarachand, the judgment debtor against whom I have a decree, he was inducted by Jivani Kumar Parak as a tenant with a right to further sublet. The applicant herein was inducted as subtenant under the judgment debtor. Kindly mark this one herein, sometime in the year 1984, with the consent of the said Jivani Kumar Parak. Kindly mark this. Very, very important. Jivani Kumar Parak not only had knowledge of the subtenancy of the applicant herein, but had also consented to such subletting. So, I am the owner. I have given the place to Jivani Parak. My friend here, let's assume for a moment what he's saying is true. He has the consent of Jivani Parak. And he claims to be a tenant, a subtenant of Jivani Parak's subtenant, who is Deepak Tarachand. So Tamal is inducted by Deepak Tarachand with the consent of Jivani Parak, none of whom are owners of the property admittedly, because the property is owned by the trust. Jivani Parak surrenders dies and his successor surrenders the tenancy. Deepak Tarachand is evicted by the court, by the High Court, for being a trespasser. It has been adjudicated that he is a trespasser and he's been evicted. Kindly see the pleadings in the plaint, my lord. Then, my lord, the applicant herein was tendering rent to his landlord, being the judgment debtor, till November 86. They are paying rent to a trespasser. After which, the judgment debtor had stopped accepting rent from the applicant herein. The judgment debtor herein had also attempted to illegally and wrongfully dispossess the applicant. And then, my lord, they say that they filed a suit. I am not a party to any of it. I am the owner. They themselves, my trespasser and his friend are litigating with each other. Tamal and Deepak Tarachan, my lord, are litigating with each other before various courts. Never implemented me as a party to any suit. Come to the High Court, go back to the lower court. They've had their own share of, my lord, litigation. Now, my lord, kindly come to paragraph 8. Mark this. This is very, very important. This is very, very, very important. In the meantime, the subject property had devolved upon the decree holder herein. Kindly, my lord, note. However, the applicant is not aware of the details of such devolvement in favor of the decree holder. This is, my lord, an admission. This is an admission, my lord, by my friend, which after 5 days on the 6th day, he can't withdraw now, that they did not even know me. So the question of getting my consent or me being a party to their induction as a subtenant or a trespasser or in whatever capacity does not arise. When I, as a landlord, I am evicting tenants or trespassers whom I recognize. My lord, I can't make the entire world a party. Otherwise, my lord, I'll keep making people parties and this matter will never end. I sue my tenant. Then the tenant says, no, I have a subtenant. Then I implead him. Then that subtenant says, no, I have also inducted somebody. My lord, the word eviction would go from the dictionary then. It will become extinct. The line has to stop somewhere. So I sue, my lord, whom I have to sue, against whom I have a locus, whom I recognize that yes, this is a person who's there, who's a trespasser. Paragraph 8, my lord, is an admission that there is no privity of contract between us. I have never ever consented in my life for him to come into the property. He's a complete alien to me. And he also says I'm alien to him. He doesn't know when the property devolved upon me. The truth is that I inducted Jivani Parak in 1970. I am the trust. I have had this property since Adam and Eve. Forever. Constant owner. Now, my lord, kindly, my lord, now see, my lord. I'm sure lordships, my lord, are well aware, my lord, in fact, more than me, perhaps. But, my lord, may I just cite two basic decisions, my lord, on first principles of when is it necessary for a subtenant, assuming if I elevate him, glorify him to be a subtenant, he's claiming his rights under a trespasser. Let's glorify him to call him a subtenant. Even then, when does a subtenant have to be made a party? By a landlord who's wanting to evict his tenant. In what circumstances does a subtenant have to be made a party? And in what circumstances that it's not necessary? The decree against the tenant would bind the subtenant. But because tenant can't give more than what the tenant has to his subtenant. Deepak Tarachan could not have given Tamal more than what he himself had. Now, my lord, may I just cite, my lord, these two decisions, my lord, just two paragraphs each. Very well settled propositions. First one, my lord, is AIR 1964, Supreme Court, page 1889.
Page
1889. May I just hand over, my lord, the judge? Kindly, my lord, come to paragraph 12. Kindly, my lord, come to paragraph 12. Taking the last, is my lord there? Taking the last action, first with Raghuvanshi's omission to implead the appellant, it is quite clear that the law does not require that the sublessee need be made a party. It has been rightly pointed out by the High Court that in all cases where the landlord institutes a suit against the lessee for possession of the land on the basis of a valid notice to quit served on the lessee and does not implead the sublessee as a party to the suit, the object of the landlord is to eject the sublessee from the land in execution of the decree, and such an object is quite legitimate. The decree in such a suit would bind the sublessee. This may act harshly on the sublessee, but this is a position well understood by him when he took the sublease. The law allows this, and so the omission cannot be said to be an improper act. Kindly, my lord, mark this paragraph. So if I am, my lord, the landlord, and I have a tenant, and that tenant, without telling me anything, brings in a sublessee, and I know for a fact that some sublessee is in possession, but I will file a suit for evicting my tenant, and the decree against my tenant would bind the sublessee, because the sublessee knows that his rights are flowing from the tenant, and the day the tenant's rights come to an end, even his rights would come to an end. Otherwise, my lord, if this would not have been the law, then sublessees would keep adding to the property and there would never be any eviction. But there is one exception. Sublessee can have a claim if he shows that I consented, that yes, okay, fine, you come. If I give consent, if my deed which I execute in favor of the lessee provides for the lessee to also bring in a sublessee, and I'm given notice, subletting, my lord, without consent of the landlord is a ground for eviction under the Premises Tenancy Act. This is, my lord, the law. Kindly, my lord, one more judgment on the same proposition and I will rest my case. Your Lordship would, my lord, kindly consider 2004, Volume 8, Supreme Court Cases, page 706. Paragraphs 25, 28, and 29. Is my lord there? Yes. It was contended by learned counsel for the respondents that the respondents were not made the party defendants in the suit, and hence no decree could have been passed, nor could be executed against them. We are afraid we cannot uphold the contention. If it is the case of the plaintiffs that the property was let to Papa Mia, it is not even the case of the respondents that they were the tenants of the plaintiffs. They are claiming through Papa Mia. Malad, in our facts, Malad, Papa Mia is Deepak Tarachand. If I elevate Deepak Tarachand to be a tenant, he was a trespasser anyway. So our case is even better. But if I elevate Deepak Tarachand's stature, going by my friend's pleadings, then Deepak Tarachand becomes a tenant, and they become his subtenants. In this context, Malad, kindly see. They are claiming through Papa Mia. So Tamal is claiming through Deepak Tarachand. At the most, therefore, they can be said to be subtenants. That is, tenants of Papa Mia. Where there was no privity of contract between the landlord and the respondents. Kindly mark this. And kindly correspond this with their pleading in paragraph 8 of their execution in their intervention application. There was no privity of contract between the landlord and the respondents. In our opinion, therefore, it was not necessary for the plaintiffs to join the respondents as defendants in the suit, nor to give notice to them before initiation of the proceedings. The respondents cannot be said to be necessary party to the proceedings. Then, my lord, paragraph 28, a judgment, my lord, has been relied upon. And then kindly come to paragraph for the same proposition, another judgment, my lord, has been relied upon. This is, my lord, the case that I Kindly see paragraph 29 now. In our considered opinion, the present respondents could not be said to be necessary party to the suit. Non-joinder of the respondents, hence, would not make a decree passed by the Court of Small Causes, Bombay, a nullity or inexecutable. The High Court erroneously proceeded against the well-settled principle of law by observing in the impugned judgment that since the respondents were claiming through Papamia and as they were not joined as a party in the suit, the orders passed by the court would in no way affect or bind them. The above observation, in our opinion, did not lay down the law correctly. So, the only case my friend has a locus to come and address the court. Of course, anyone can come and address the court. But when they address the court, they have to show the court that they have a right in the property and they should not be evicted. That right cannot stem from somebody against whom a decree of eviction has passed. That right has to stem from the landlord, from me. And in paragraph 8 of their own intervention case, they have called me an alien. This itself shows that I could never have inducted them or they could have never sought my consent. Kindly, my lord, appreciate. Otherwise, never will any eviction happen. Subtenants will keep getting added, my lord. Today, I'll, my lord, make Tamal a party. Then tomorrow, the third person will come up. Tamal's brother will come up. Kamal Banerjee will come up. And this will go on. But line has to be drawn somewhere.
Okay.
If my lord, after this, if my lord feels that yes, my friend can perhaps better his case in any way, he would, my lord, perhaps file something or the other. But the fact that I am an alien and he never had my consent and there was no privity of contract between me and him, this can never, my lord, be established in a new application or a supplementary affidavit or in any way. And whatever litigation he may have had with his friends and his the trespassers and etc., that is between them. Nothing binds me. I'm the landlord. In the hierarchy of rights, I'm right at the helm. Everything stems from me. And if I have a decree against someone, no matter who I have a decree against, my lord, it will bind everybody who claims under the judgment debtor. Unless there is an exception, and the sole exception, namely that I have a privity. I gave him consent. I allowed him to come as a subtenant. It was with my knowledge. Then yes, then he can always, my lord, say that I should have made him a party to the suit.
That's all.
This is it, my lord. Kindly, my lord, there is already an order passed by your lordship to hand over khas possession to me, my lord. Kindly, my lord, do not interfere with that order is my prayer, my lord. The learned receiver, my lord, I believe would be resuming work in 2 or 3 days' time, my lord. Kindly, my lord, let him, my lord, continue with the task for which he was appointed. And kindly, my lord, dismiss this application in the limine. There is no need for me to, my lord, file a reply because by his own pleadings, there is no case. If I elevate the decree, then there is no case. And my lord, the fact is that he was a trespasser. Kindly have a look at my plaint. I have gotten a decree against the defendant who I have called a trespasser. I didn't call him a tenant or a subtenant. He was a trespasser. Your lordship will see the plaint. He's a trespasser.
Okay, that's all.
That is all.
Anything else on law points?
4 points. Lordship, in respect of limitation, Lordship, subject to correction, my learned friend could not make out why this time should be excluded. Lordship kindly takes up to order 20, rule 7.
Order
20.
Order 20, rule 7. Yes.
Date of decree. The decree shall bear the date, the day on which the judgment was pronounced, and when the judge has satisfied himself that the decree has been drawn up in accordance with the judgment, he shall sign it. Lordship, it is his own tabular statement. He has stated the date of the decree to be 6 September 2010. And Order 20 Rule 7 also provides that the date of the decree will be the date when the judgment has been pronounced. It will be the same date. So the period of limitation will start running from the date when the judgment was passed and not when the decree was drawn up. He may take 2 years, 3 years to draw up a decree. That does not extend the period of limitation. Lordship may kindly appreciate this. My learned friend is saying that he had got it in 2011. Even after getting the decree drawn up, he's waited for 10 years, 11, 12 years almost. He's filed it in 2023. Your Lordship may kindly appreciate the delay. It's not a delay of 1 month or 2 months. Your Lordship, it's 12 years. It is his own tabular statement, column 3. Your Lordship will kindly take it up once again. Date of the decree, it is impleted by himself. This is his statement in his execution petition, 6 September 2010. If after 5 years I go up and apply for a drawing up of decree and then say that the decree has been signed in 2000, the order was passed in 2010 and the decree was drawn up in 2015.
Whose duty it is to drop the decree?
It's the plaintiff's duty.
No. It's the court's duty to drop the decree.
Court's duty upon application by the plaintiff.
Right.
It's upon application of the plaintiff that the court will drop the decree. But your Lordship, the decree's date will still be the date when the order is passed.
It is on application of the
Plaintiff. On
please,
whoever
holder.
party, degree holder.
So show me that where is that? Where is that provision that this is on the basis of application of decree holder, the decree shall be drawn up? Show me. It's a duty of the court, I think.
No, your Lordship.
I may be wrong.
Lordship,
You please.
Lordship, I might also, your Lordship, there are judgments to that effect as well. That the mere fact that the decree was drawn up later does not extend the period of limitation. Your Lordship, I'll bring those judgments as well.
You are not ready with.
You're not. I do not have.
Come back
this.
tomorrow.
Very well.
You have to satisfy also this. That on application of decree holder, the court has to. If you do not make any application,
kindly see Article 136 of the Limitation Act. It will end it there.
Oh.
Kindly have a look at the statute itself, which my friend cited.
136, yes.
136. For the execution of any decree other than a decree granting a mandatory injunction, it's not from the date of decree. Kindly see the limitation starts when the decree or order becomes enforceable.
The order
so decree may be of any date, but it will become enforceable only once the decree is drawn. And I have, my lord,
this was.
My lord, I have applied. I have shown, my lord, the application.
Let him. Okay, I have got your point now.
And assuming, my lord, assuming that this
is on application, the decree will be drawn up.
Lordship.
It is your submission.
Lordship.
Show me the law.
I'll come back with that. And also,
Come
I'll
back
come back
tomorrow?
with judgments.
Yes.
Day after tomorrow.
No.
Tomorrow. Very well. Very well.
Tomorrow. Okay. Come back tomorrow.
My lord, may I just say one thing? My lord, this is an academic exercise. I would love another appearance in the matter. My lord, lawyers, my lord, we always, my lord, there's no difficulty in coming back tomorrow. My lord, all I'm saying is this might perhaps be an academic exercise. Because even if I, my lord, disregard everything, even if I
He wants to show me the judicial decision. What can I do?
Very well.
This is not an academic exercise. If this is so, then your Lordship, his execution petition is barred. How can he say that this is an academic exercise?
I've done the math. I've shown the math to your Lordship that even if I take
best window dressing my learned friend could have done, stating
Okay,
that this is an
come back
academic exercise.
tomorrow. The learned council has submitted the decree. The decree shall be drawn up only on the application of decree holder. Short point, you will get only 10 minutes time. Okay. You have to complete.
There are other points as well.
Okay.
One of the points.
You have completed everything.
Lordship, only to reply to the
Yes,
law points.
on law points.
One of them was limitation.
Yes. Okay, order for this. The learned counsel for the parties have submitted in respect of the application, submitted their place their arguments in connection with GA 1 2024. Stop. The learned counsel for the intervener, proposed intervener, has sought for an accommodation for replying on points of law. Stop. Please the master tomorrow. Abhi Kaudari,
21st.
21st February. Okay.
Grateful, mother.
না না এখন হবে না আইটেম নাম্বার 9
My lord, Mr. Kaur is appearing in this matter. He is engaged in another court. My lord, can you fix the matter at 2 p.m.?
That
Yes.
That matter, the correction has
What
been made over the
He seeks for an accommodation.
He was at 2 p.m.
2 p.m. Yes, yes. At 2
Today at 2 p.m. It can be disposed of.
Okay, 2 p.m.
2 p.m. হ্যাঁ পাস ওভার করে আইটেম নাম্বার 10
Well, I am praying for a short Passover, my lord.
পাস ওভার পাস ওভার
Next.
আইটেম নাম্বার 11
Lord, I appear for the decree holder. Lord, this is the matter where Mr. Banerjee was making his submissions.
Yes.
My Lord, I have taken out an application for civil imprisonment. Perhaps it's appearing in the list, but perhaps the papers are not yet there in court.
Why? Say, put us a paper as in.
We had taken it out yesterday.
Oh, I'll get application. So, shall I adjourn?
My Lord, Lordship can keep this matter tomorrow, my Lord, or the next week I'll come and address your Lordship on the civil imprisonment. I'm under some medical condition, my Lord, that's why I couldn't come today.
You are appearing for?
Judgment debtor.
And he's.
I'm for the decree holder.
Yes.
The judgment debtor is out of the town, so kindly keeps it after a week. The next week you may.
My Lord, it's irrelevant because, my Lord, I'm seeking the imprisonment of the judgment debtor.
Okay. So you are also praying for accommodation for 1 week. So I am fixing it on Monday. Okay.
Grateful, my Lord. Grateful.
The learned counsel for the judgment debtor has sought for an accommodation. Stop. Please the matter. Monday,
26th, my Lord. Monday is 26th.
Yes. No, there is no holiday. State government holiday. Okay.
26 February
Grateful.
state government
Now, next.
item number 12
Judgment debtor. Who is for the decree holder?
Sir, my lord, our judgment debtor is also present, my lord.
For examination of. Hey, এটা কি হলো?
My lord, in item number 11,
অন্যগুলো ডাকো তো 500 বার যেটা
my lord, in
আছে। কি প্রডিউস জজমেন্ট নাকি? ও ঠিক আছে ভাই। খালি এইটা থাকো এই আর এক্সিকিউশন কেসে আরেকটা আছে হ্যাঁ নট টু হলো ওটাও দুটোই করা কি করবো না এই আসে কিনা
আপনাদের একটু সময় লেকডাউন থাকবে হ্যাঁ লেকডাউন থাকার সময় ইনফর্ম করেছি
Team number 1 তো?
ভালো তো 500 বার হলো তো দুটোর সময় বসবে
তাহলে কটা বাকি থাকলো?
Item number 3 has been passed over and kept at 2 p.m.
হয়েছে কালকে কিরকম আছে? কালকে না পরশু দিন অনেক দেরিতে নাও আসতে পারে বিশেষ নিয়ে চলে যায় তাহলে কোনো অসুবিধা আমি বলে রাখলাম ঠিক আছে আপনি
Passover matter, commercial division, item number 1.
Lord, I appear for the decree holder, my lord. This was passed over for the police authorities to produce the judgment debtor.
Yes.
I believe the sheriff has produced the judgment debtor.
Yes. Have you gone through the reports?
No, my lord, we have not been furnished with a copy of it, my lord.
Please go through this report. You please go through the reports first. The deputy sheriff has submitted a report. Two reports. Stop. Two reports along with the information received from the police authorities. Stop. It appears from the police report that the police authorities have tried to execute the warrant of arrest, but they could not do so as both the premises were put under lock and key, and it is further reported that the judgment debtor is hiding for the purpose of avoiding arrest. Stop. As per reports, his whereabouts are unknown at present. Stop. Please tell.
My lord, in such circumstances, my lord, there have been orders passed by this Hon'ble Court directing the Commissioner of Police to take steps and ensure the presence of the absconding judgment debtor before this Honorable Court, and the warrant of arrest is made returnable after 2 weeks. If your lordship can direct the sheriff to take steps and intimate this order to the Commissioner of Police and to act in terms of this order, my lord. Because, my lord, under protocol, the sheriff of Calcutta is higher than the Commissioner of Police, and he has to act in terms of the directions of this court. The police cannot file a report that he is absconding, and they can shrug off their responsibility.
Submitted reports, I think. Absconding.
Yes, my lord.
They submitted reports. Police
My
submitted.
lord, that will not do. The police has an obligation.
Please come back tomorrow and file an appropriate application. Stop. The learned counsel is for the decree holder is directed to submit appropriate application in view of the aforesaid circumstances. Please the matter tomorrow.
My lord, I was only praying, my lord, since Mr. Ghosh is medically unfit to appear before your lordship physically, can it be kept on Monday, my lord?
Yes, why not?
Very well, we'll come back on Monday.
What happened to you?
My lord, I have, it's called paroxytitis. It's basically, my lord, mumps.
Oh, I see. Okay.
26.
I don't Monday.
I'm grateful.
26. Okay.
Grateful, man.
Bobby Passover. Original side matter, Passover matter, item number 3.
My lord, here, my lord, the judgment debtor appeared and wanted to return at 2 p.m. with, my lord, the draft of rupees 3 lakhs.
Yes.
Yes,
Well, Mr. Kasimuddin is there, my lord. I believe he has the draft of rupees 3 lakhs.
The only thing is that we have talked to the other side and they have agreed to withdraw this case. But there is one, they have also principally agreed to withdraw criminal cases against me because there's a check bounce case.
My lord, we have no difficulty.
And if that can be observed in the order sheet, because
If it is a draft, we'll immediately accept it and lordship can dispose of the proceedings.
My lord, we have instructions, ma'am.
What is that instruction?
But those are written instructions from the client. My lord.
And lordship, there was an order of injunction against my client. It was passed on 13th September 2021, where my bank account was also freezed.
It has been written there that they are ready to close the instant case. It is not about the other cases. It has not been noted that
That is what
criminal
I've been told
cases.
to by Mr. Sharma yesterday evening that they will also withdraw the criminal case.
Okay, then
Otherwise, I'll be
Lordship, those are my instructions. Lordship can record it, my lord.
I've given the case number also, Lordship.
Yes, why not? Give the case numbers. Handover.
I mean, handing. He's gone for Xerox coming. 1 minute.
Okay.
I have seen the draft. It's a demand draft.
Okay.
For sure.
The learned counsel for the judgment debtor
Yes, I have received it.
has handed over a draft of rupees 3 lakhs to the learned counsel for the decree holder. Stop. Para. The learned counsel for the decree holder, Mr. Ghosh, has submitted that his client will withdraw the instant proceeding as well as the other criminal proceeding pending before where?
Before the learned 15 Metropolitan Magistrate 15 court.
I'll
give the case number.
Case number stop. In view of the above,
Which case number?
the instant
15
the instant execution proceeding stands dismissed as withdrawn.
There was an injunction against me earlier also that my account
In this case,
Lordship.
the interim order stands vacated.
That is just note on the because my bank account has been freezed. So I have to show that this order has been vacated now. As per the
The interim order passed on 13 September 2021 by this court stands vacated. Number গুলো নিয়ে নেবেন।
May I also keep the Xerox copy of the draft with the record also?
এটা রেকর্ড হয়ে গেল।
Great.
এটা না। Item number 9.
Again.
The order for a deed of transfer is to be executed by my learned friend. I have corrected the tabular statement. Yes.
Tabular statement, yes. As per, এই আসুন আসুন সময় নেই হতো as per direction, the tabular statement has been corrected by the learned counsel for the decree holder. Stop. The learned counsel for the judgment debtor is also present and has submitted that he has no objection if necessary order is passed directing the AGOT Kolkata,
West Bengal,
to execute the relevant deed of transfer in favor of the decree holder after complying with all the legal formalities. Stop. Para. Accordingly, the AGOT West Bengal is to execute the deed of the relevant deed of transfer as per the revised schedule as mentioned in the tabular statement of the tabular statement. Stop. By 15 days.
Lordship by 15 days.
It is
Not the
required.
better for him because now that he's on transfer.
Yes, yes. Within 2 weeks.
Gotcha.
Stop. The learned counsel for the judgment letter is requested to communicate this order to the AGOT West Bengal immediately.
And my lord, all costs involved for registration and all will be borne by the decree holder.
Stop.
That we
The entire cost for registration and ancillary purposes shall be borne by the decree holder. Stop. That's all. The execution case stands disposed of on full satisfaction.
Lordship will kindly wait for the deed to be executed.
Okay,
before.
no. Release the matter after 3 weeks.
3 weeks.
It will be done.
Well, I hope it will be.
12
My learned friend has been very helpful.
Yes.
I hope it will be done.
Okay.
12 March.
Try my best, my lord, to solve the matter.
Okay. Thank you. Thank you.
Item number 10.
Oh, this is an international matter.
International. It's international.
So bring international judge here.
No, judges are here. The lawyer will go international to do the matter. No, my last order, last order. Dear, my lord's last order. My lord's last order recorded, which fell from my lord. I was also going through that. The section 45, she was recorded my lord's last order. See that 43 to 45 that says that court has to be established.
Central government, by the authority of central
Yes.
government.
Now, with that, lordship will kindly see the agreement.
Yes.
Which is, I rest my case on the agreement between the two parties. International agreements are recognized under the constitution that the government should do. Now, this agreement has a binding force on both the government. This agreement between the Ministry of Law and External Affairs. I rest my case on the agreement, and this agreement gives the way how the procedure, how this will be laid. So today we have not on the civil procedure code because that court has to be established. Now we are specifically on this agreement, and this agreement clearly says the mode and the manner has to be
So have you submitted any application to that effect? Or only so that you are praying for transmitting the same only to the Ministry of Law and Justice?
Yes, that's them. Lordship will see.
Is there any prayer? Or
Yes, prayer is there. There two prayers are couched in one. Prayer is there. Lordship, I'm making the submission. Lordship will pass orders to that effect. Yes, only to that effect. An order be transmitting the decree. The competent court in Dubai having jurisdiction over the registered office in such and such through the Department of Legal Affairs to the execution Legal Affairs New Delhi for execute said decree in New Delhi. So it has to be through the Legal Affairs New Delhi. So my lord's department will have to transmit to the New Delhi. Rest the New Delhi will do in terms of the agreement between the parties. The rest the New Delhi will.
But there is no provision in CPC. That is the only problem, because you are saying that I am relying on the reciprocating agreement.
Judgment, yes.
But that is not mentioned in any of the provisions of.
May not be, Malan. May not be.
Shall we take expert opinion?
No, I'll tell you, Lordship. Lordship is sitting in a court of equity.
Yes.
It's not other courts which are bound by the civil procedure code. It is
So
not bound.
this is you have said, so far as your prayer is concerned,
It is only Lordship is not adjudicating anything.
It does not tally with your submission. Order be passed transmitting the
My lord, it also says necessary certificate for non and such further orders as the court may deem fit and proper. Today, Lordship, I am resting my case on the agreement only, and on the agreement, Lordship is sitting in a High Court jurisdiction, which is having Chartered High Court having powers beyond the Civil Procedure Code also. And I'm not asking exercising our power in equity. This is under the agreement between the two.
Has to act under the law of the land.
Law of the land is the agreement.
Agreement. But
yes.
But this agreement is not recognized in the provisions of CPC.
That's
not required.
The Lordship have to hold this. Lordship will not bind by this agreement. Lordship will hold that. I will take up the matter with the ministry. Lordship will then have to hold
Exactly.
that Lordship will not.
That will help you. I shall hold that this is it does not allow us me to send the matter to.
Lordship will have to hold that then.
Then you have to take up the matter.
I will have to take up the matter.
That's why I am saying that expert opinion is required. If these legal affairs personnel or anything.
Lordship will see. Is a private litigation. Nobody will do all these things. These are things, my lord. I even found out a division bench of Kerala High Court where the decree was passed
Show
by.
me the judicial decisions.
Yes, this is the one. This is the decree the other way. That's was. Oh, this is the. Now even I found I am carrying the Civil Procedure Code of UAE.
Oh, you have become expert on the law of UAE.
It is the Civil Procedure Code of UAE. I found out in the internet yesterday. It's not me, my junior helped me. This is called some Abu Dhabi Civil Evidence and Judgments of Enforcement of Judicial Appointment Regulation of 2015. Even the Civil Procedure Code of UAE also recognizes what is a foreign court and how that has to be, a foreign decree will have to be executed in that country. So, and this is of 2015, the regulation of the UAE. Now, this judgment, my lord.
They're from Kerala.
Yes, this is a Kerala High Court judgment, division bench. It was happening the decree holders of a decree passed by the court in UAE. So it is the other way around. The decree was passed in UAE. Based on this agreement, Lordship will kindly see the first paragraph.
That is acceptable. That is a foreign judgment, section 13.
Foreign judgment, section 13.
Judgment can be executed.
No.
Yeah.
Section 13, if there is no reciprocity, then you have to put it and get a decree. But if there is reciprocity, you need not. Unless there is a reciprocity, because there is an agreement between the countries which recognizes a foreign decree. Section 13, CPC. There can be countries where there is no reciprocity, there is no reciprocal agreement. So I have to bring a decree, file a fresh suit here, and get a decree in Indian court and then execute the decree. But if you have a foreign agreement between the two countries, then the Indian court recognizes the foreign decree.
So this will not help me. In fact,
this is the other way around. I am saying the paragraph 4.
Yes.
The notification issued by the central government dated such and such is a declaratory notification. It is settled principle of law that the declaratory statute or a notification should operate retrospectively. But it is true that it is the other way around. Now, this also recognizes this agreement which I showed to your lordship, the agreement between the two countries, which I am showing to your lordship. The same agreement of 25th October 1999. I am not asking execution of the decree before your lordship. I am only asking the decree to be transferred to New Delhi on the strength of this international agreement.
So file an affidavit before me. File an application. Tabular statement is not creating some confusion in my mind.
But the department won't accept without tabular statement. Department won't accept the tabular statement has to be there, and the affidavit in support of the tabular statement has to be there. There cannot be a other form of execution.
আমি আগের দিনে একটা দিয়েছিলাম, এই আগের যেদিন একটা পুরো কেটে দিলাম ডিকটেশন দেওয়ার পর একটা আছে তো
হ্যাঁ, it was detailed. It was detailed. না, ওটাকে থাকবে নিশ্চয়ই, আরে হওয়া বোধহয়
দেখছি।
The advantage it is taken in a book. Nowadays, what we do, control all delete, it goes. It is not a control all delete. খাতায় নিয়েছো তোমরা?
আছে।
It must be in the book. ছাপানো নিশ্চয়ই হয়ে গেছিল, হ্যাঁ তো।
ওটা
I am only asking for the decree to be transferred. I am not asking for execution of the decree before your lordship. Now it's my client's black matter what the Delhi will do and how do I execute in UAE. Even I was going through the civil procedure code of UAE also yesterday.
লিখুন তো।
Abu Dhabi. Abu Dhabi.
The learned counsel for the decree holder has submitted that the decree was passed on 3rd August 2023 against the judgment debtor, who was a legal entity having its office at Rakia Al Hamra,
Copy it, man.
3 Zone, PO Box number 34806, behind Rack Ceramics. বানানটা দেখে নেবেন তো ceramics এর Street F-12, Ras Al Khamaia, এটা দেখে নেবেন দুবাই 8, outside the jurisdiction of this court. Stop. The decree was passed ex parte as the concerned judgment debtor did not appear before the trial court. Stop. The learned counsel has referred to section 43 to 45 of the Civil Procedure Code and also the relevant agreement concluded between Republic of India and United Arab Emirates to show that India and UAE have reciprocating agreement on certain issues. Stop. The learned counsel for the decree holder has submitted that his client would be এটাকে the learned counsel বলো ওখানটা the learned counsel his client would be টা কেটে দিই তাহলে কি জানালো learned counsel for the decree holder has submitted that purpose will be served if the decree is transmitted to the Ministry of
Lordship will
Law and Justice or Legal Affairs?
Ministry of Law and Justice.
Ministry of, but your, it does not tell you your tabular statement.
No, Lordship will see that the agreement between the parties. The agreement between the parties, page 21.
Yes, I have seen.
The authority, Ministry of Law, Justice and Company Affairs.
But your tabular statement?
These things, my lord. Lordship is a chartered high court. What is written tabular statement is immaterial.
Yes.
We go for oral prayers, appeals are admitted here, my lord. Has to be. The equity.
Ministry of Law and Justice.
New Delhi.
Union of India or Government of India. What is that? Government of India.
Government of India, New Delhi.
New Delhi.
New Delhi.
Stop. Para. After going through the provisions of Code of Civil Procedure, it appears to this court that there is no whisper that a decree originated from India can be executed in the jurisdictional court at UAE, United Arab Emirates. Stop. However, the reciprocating agreement has
the date is there.
The agreement. What is the date?
25th October 1999. Page 30.
Agreement dated. Reciprocating agreement dated. Such and such.
25th October.
25th October
1999
has disclosed that such execution of decrees passed by the courts of India can be done with the help of the courts at Dubai. Stop. However, in view of the above materials on record, And also, in view of Article 2, Clause 1, the register, original site, High Court, Calcutta, shall transmit the certified copy of the decree and other documents as mentioned in Article 23 of the said agreement to the Ministry of Law and Justice, Government of India for taking necessary steps.
Government of India, New Delhi.
Government of New Delhi for taking necessary steps after complying with all the legal formalities. Stop. A copy of this order be sent to the register, original site, High Court for her information and necessary action. Stop. For the sake of convenience, a copy of the reciprocating agreement dated 25th October 1999 between Republic of India and UAE be enclosed with the copy of the order. Stop. Let the matter go out of the list with liberty to mention.
Yes, out of the list. But the prayer B of I need a non-satisfaction of the degree certificate. That is because that is the one of the main things. Non-satisfaction of the degree certificate. I need that certificate.
As per submission of the learned counsel of the decree holder, the decree has yet to be satisfied.
Yes, yet to be satisfied. Yes, decree yet to. See, Kushikda.
You are controlling. You are being controlled by
Yes. Controlled by solicitor. That's most important control.
Solicitor.
Solicitor. Most important control in the original site.
Is yet to be. Is yet to be.
Is yet to be. তার মানে non satisfaction.
এটা রেখে দাও এখনো কাজে লেগে গেল।
Is out of list. We can mention the matter after the formalities.
Yes.
You must praise me. Today I have done him an international matter.
Yes.
You must praise me, no? I'm
Yes.
sorry. Sorry.
Okay. এটা নিয়ে নাও।
Sorry, man.
Taken out of phone order file. Taken out of item number 12.
But I was examining, my lord, the judgment debtor on the last occasion, my lord. And if your lordship would recall, my lord, Mr. Mukherjee was appearing for the judgment debtor, my lord, and he had, my lord, prayed that if, my lord, a 7 days time could be accommodated so that, my lord, he could file an appeal. But we have not received any copy of the appeal or any other application, my lord, because he had said, my lord, there are.
Judgment debtor was present in the morning. In the morning he was present.
That
yes.
we do not know, my lord. That we do not know.
Accommodation sought for on your ground. Yes.
Well, it is her advocates who should be present in court, my lord.
Yes.
Because for a litigant, my lord, she cannot follow the board. She cannot. She wouldn't know how to follow a board, my lord. That, my lord, benefit of doubt has to be given to her, my lord. But the advocates, my lord, because there are at least, my lord, 5 advocates representing her.
So, he is not present. What can I do now? Please suggest.
As a last chance, if you, my lord,
the learned counsel
and lordship will kindly record, because in the last order, lordship has recorded that, my lord, Mr. Mukherjee, my lord, intends to take out some kind of application, my lord. We've not received any. One. Second, my lord, if your lordship would kindly record, my lord, that, my lord, the form in which, my lord.
If he is not present, if he does not submit anything, how can I say there?
That's my submission. That's my submission. That we have not received anything. That can always be recorded. Second, my lord, this affidavit of assent, my lord, if your lordship remembers, my lord, on the last occasion also, my lord, I had said that this is not in proper form. This has to be, my lord, in terms of, my lord, form 16A of Appendix E. This is not in form, my lord. Again.
Now you have already cross-examined him in part.
That does not, my lord, amount to waiver. That does not amount to waiver because I've been taking this point right from.
You have to complete the process. We shall take appropriate.
That, my lord, I can, my lord. The process will be complete only if she's present in court, my lord. I leave it to your lordship, my lord. I leave it to your
The
lordship.
learned counsel for the judgment debtor is present. Stop. Neither the judgment debtor nor his counsel is present even in the second call. Stop. Para. The learned counsel for the decree holder has further submitted that he did not receive any appropriate application or intimation of appeal from the learned counsel of the judgment debtor. Stop. Para. This is the matter on সোমবার করে দাও তো
26th.
For further examination.
We kept on 27th.
Further cross examination, no? It must be further cross examination.
For further examination of judgment.
Further examination. Further examination of the judgment debtor. Stop. The judgment debtor must be present personally. In default, necessary coercive steps will be taken. কিছুই হবে না.
Cannot be. She's a woman. Cannot be.
Oh, she's a woman. Oh,
Coercive steps, my lord, under the CPC in case of execution is not possible. Although, my lord, I have a different, my lord, modus operandi for doing that, but in execution, my lord, it is not possible. Coercive
এটা লেগে
steps.
যাবে না.
In default থেকে মানে
It is better, my lord, because if
Must be
there's
present. Must be present person.
because only those orders can be passed, my lord, which are executable, my lord. This, if
Exactly.
lordship even says so,
No. Why?
because of the code, my lord, lordship will not be able to.
It cannot be.
Yes, it cannot be.
I've thought that he's a male.
No.
Okay. So,
My lord, only one humble request. Lordship has kept it on 26. My lord, can it be kept on 27th instead of 26?
yes, why not?
27.
27.
27. Oblige, my lord, deeply.
Intimate your brother if possible.
I shall, my lord. At least Mr. Mukherjee, I'll tell him. My lord.
Okay. Think you are. কালকে নয় তো পরশু দেখেছি পরশুই নয়
In fact, my lord, I was
22 তারিখে ঠিক নেই 21 তারিখে ছিল কি করেছি for hearing 3:30 p.m. কিছু একটা হবে 3:30 তে আর পরশু দিনও আছে তাহলে তাহলে কালকে আমার এখানে কি দুটোর সময় কিছু আছে নাকি কিছু টাইম ফাইম ফিক্স করা যাবে না বুঝলি তো কখন কোথায় এসে যাবো আমি। আর 22 তারিখে তো আছে 22 তারিখে ঠিক আছে